right, good evening, everyone. Welcome to the May 9th, 2017 Town of Ashland Zoning Board of Appeals meeting. Officially called the meeting to order. So the first agenda item, as always, are the minutes, and we have two of them. You want to run us through those quickly?
I was not at the meeting of April 4th, so I would abstain from any voting, but this was the hearing on 23 Washington Street, appeal of the building inspector's permit. Josh distributed the draft set of minutes to us some time ago.
Mm-hmm.
Hopefully, if there were any proposed changes or corrections, they were sent to him long before this evening.
Yeah, I believe there were, and I think those are updated. I think, yeah.
Some of those.
So, any comments on these minutes?
Nope.
Okay, well, let's just do a motion on both, and then,
Okay, well, I do need to abstain from the first one.
oh, that's true, okay. So I'll entertain a motion to approve the April 4th, 2017 minutes as drafted.
I second that motion.
Wait, you gonna make it?
Oh, I gotta make the
You
motion.
make, just
Yeah,
say,
I make
yeah.
it, yeah.
All in favor? Aye.
Aye.
I abstain.
Opposed, and one abstention. Okay. Want to do the 11th?
Okay, next one is the minutes for the April 11th meeting, one-page brief. Again, Josh distributed those to us prior to the meeting some time ago. The only addition that I am aware of is the second sentence of the first paragraph indicating when Phil left the meeting and that Tom became chair thereafter. And they seem fine to me otherwise.
I make a motion, we accept the meetings, the minutes from the April 11th meeting.
Second.
All in favor?
Aye.
Aye. Opposed? That's unanimous. Okay, so I am informed by town council that we don't actually have to open meetings exactly at the posted time. We just can't open them in advance. And so it is now like 7:04. We've got something coming on at 7:05, but we have one item before that, so which I don't think is going to take too much time, but I'll just read. So as the agenda reads, reposting from April 11, 2017 meeting, we're going to confirm deliberations and approval of decision and appeal of the building inspector's grant of building permit BP-2016-701 relative to property at 23 Washington Avenue as filed by Catherine Jerzik and Janet Platt, Philippe Romero, and Alva Romero. Original deliberations and approval occurred on April 11, 2017. They were subsequently the subject of an open meeting law complaint, and remedial action is proposed to be undertaken to confirm the board's action. So that's, I think we'll take that first. So I'll turn it over to Adam, Town Council.
If I could, Mr. Chair, I might suggest that you continue reading the last sentence because we're actually going to take them in reverse order. I think it'll be a bit simpler.
Okay. Discuss proposed response to the open meeting law complaint received from Stephen Morgan dated April 17, 2017, and related to the board's actions at its April 11, 2017 meeting. A vote is possible.
Okay, thank you, Mr. Chairman, members of the board, members of the public. So we received, my office received, having been submitted to the town through town staff, an open meeting law complaint filed by Mr. Steve Morgan. This particular complaint was dated April 17, 2017, and referenced an alleged violation or multiple alleged violations that occurred at the board's meeting of April 11, 2017. I did forward copies of that complaint to board members via email. I have a hard copy, a single hard copy here, which I'm going to pass around in the event that the board members would like to review it if they didn't have an opportunity to review their email. To give you a bit of information about the open meeting law complaint process, just so you understand how it all works, is open meeting law complaints can be made to a municipality with respect to any meeting of a public body where a complainant believes a violation has occurred, and that gets submitted generally through town staff. Sometimes it's to the town clerk's office, sometimes it's to the town manager's office. The unfortunate thing, the legislature, when it adopted these provisions, didn't recognize maybe the reality that municipal boards don't always meet with great frequency. Sometimes they meet only on a monthly basis, sometimes particularly in the summer, less frequently than that. And so the challenge becomes there is a 14 business day turnaround for response to open meeting law complaints. And so the process that we usually undertake, and I've explained this to multiple other boards and commissions in Ashland and other communities who have the same question, is we take direction, often from the chair of a particular board, as to whether or not we should begin to prepare a proposed response from the board. I'm not purporting to speak for the board. I'm not submitting any sort of response to the Division of Open Government on the board's behalf until I get you to review it and approve it. But in the interest of efficiency and meeting our deadlines, I generally begin to prepare those responses based upon the status of the law in Massachusetts and what I know about the instances of alleged violations that occurred. So that's exactly what occurred here. I had a conversation with your chair. Your chair authorized me in my office to begin to prepare a response to the open meeting law complaint, and I'm going to provide to you now copies of a draft, which I also circulated to you via email, but of course there can be and has not been any deliberation about that letter, that draft letter via email, so as to comply with the open meeting law. So there were two components to Mr. Morgan's open meeting law complaint. The first related to the discussion that occurred at the board's meeting of April 11th concerning the written decision on the 23 Washington Avenue proceedings, which occurred 1 week prior. I was at that meeting a week prior to the 11th on April 4th. The allegations were that that discussion should never have happened because there wasn't any explicit reference to it on the board's agenda for April 11th. And the second alleged violation related to a discussion that occurred at that same meeting concerning potential representation of pro se applicants to municipal boards, and whether there ought to be some means by which the town staff or the board can direct these pro se applicants to some form of legal service or local attorneys or whatnot. I know so much about this because, of course, your meetings are televised, so before I prepared the response, I watched your meeting, so I had a sense as to what occurred. So the substance of the response, to walk through it very quickly, is in two parts. The first, which begins halfway down the first page, is entitled Amendments to Written Decision, and speaks about the decision that was proposed to you on the 11th and the fact that there was a brief discussion among board members concerning that decision. And then my understanding is your staff members stepped outside the room, made copies of the decision after making a few modifications consistent with the board's discussion, and then brought it back into the meeting room so that the board could sign it. As I've described here, the general rule is that when members are in attendance, whether it be at a regular meeting or a special meeting of the board, it's not uncommon for boards to sign decisions that were previously rendered. Because I was at your meeting on the 4th of April, I know that you voted not on the 11th, but on the 4th of April to approve that decision. The discussion of changes was, number one, unexpected. So the rule of thumb with respect to posting agendas is that the agenda needs to identify all matters that are reasonably anticipated by the chair. The expectation that evening was to sign a decision that had been drafted consistent with the board's prior vote. It wasn't a circumstance which has occurred with your board in the past. For example, when I attend a meeting for the purpose of deliberation on a decision and the board hasn't taken a vote yet until we work out the details of that decision and you have a formal document before you, the sole intention that evening was to sign a decision based upon a vote that previously occurred. But of course, there was some discussion that took place concerning the substance of it. So the position here is based upon my familiarity with the open meeting law and the dozens of cases that have been issued by the Division of Open Government interpreting it. I don't believe that an open meeting law violation occurred by virtue of you discussing a few nominal changes to that decision that didn't change the substance of your vote at the prior meeting. The second point, which begins about halfway down page 2, is this discussion of potential legal representation of pro se applicants to this board or to other boards in Ashland. And I think this one is even more clearly not an open meeting law violation, really for two reasons. The first is it was entirely an unanticipated discussion. That was clear just from the responses by several of the members who were in attendance. That discussion was prompted by one member of your board, and it was really more of an impromptu conversation that occurred when your staff stepped outside to make copies of the decision for 23 Washington Avenue, and the board members were simply here in the meeting room and elected to have casual conversation about the issue of representation of applicants before boards. The second issue is that or second basis for my determination that there's been no open meeting law violation is that this is a matter that is squarely outside of the board's jurisdiction and purview. You don't have jurisdiction over, nor is it within your purview to consider whether applicants to your board should or shouldn't be represented by counsel, or whether staff should or shouldn't recommend local attorneys or legal service organizations to assist those pro se applicants. So it was a casual conversation, was not reasonably anticipated, was entirely impromptu, and was something that was entirely outside of your jurisdiction. So the determination that I've made, and hence the position that I've expressed in the proposed response on the board's behalf, is that there has been no violation. With that said, it is always my recommendation to boards that when matters of this sort are brought before them, that to the extent that there is any argument that could be made by a complainant that there has been a violation, that you take corrective action as appropriate. And so, again, because I think that this impromptu discussion of legal representation is something that is highly unusual and really outside of your jurisdiction and not a matter for your discretion, I don't believe any remedial action need be taken in that regard. With respect to the discussion of the decision, there's an argument to be made. I don't believe it to be an especially persuasive one, but there's an argument to be made that there should have been no discussion of the decision. It simply should have been, please ink your signature on the final page. Again, knowing what was discussed and knowing the changes that occurred to the decision, now that I've reviewed them, those changes were not significant. I would call them nominal. But nevertheless, the suggestion I've made, and it's the first item that your chairman just read a moment ago, was to repost, which you've done for tonight's meeting, and then simply to verify your vote in an open session. Again, it was not a continuation of the public hearing, so you need not open a new public hearing and give the public an opportunity to speak, because they wouldn't have had that opportunity at your meeting on the 11th anyway. The hearing was closed on the 4th and the board voted. It was simply a discussion and a signing of the decision. So I would suggest that you memorialize that action at tonight's meeting. If you do that now, that is referenced in the proposed response to the open meeting law complaint, that you've taken that remedial action at tonight's meeting, and it would be my recommendation that you do that, and that you authorize me to submit this response on your behalf to the Division of Open Government. The division will then review the response. They'll contact me, and I'll contact you with any further questions that the division might have, and then the division will issue a determination as to whether there's been a violation. Happy to answer any questions you might have.
I am a little logistic on that, but any sort of higher level questions? Okay, so exactly what do we need to reaffirm? Because no vote was taken that evening. So just the general discussion and the corrections that were made?
Well, that's the uniqueness of what's being requested here. As you say, there was no vote taken, which is part of the basis for our determination, my determination, that there's been no open meeting law violation. But for purposes of tonight, I would suggest that the board do take a vote, or does take a vote, that confirms that it intended and did sign the decision, and that decision was consistent with its vote at its April 4th, 2017 meeting.
That might be the strangest vote I've ever taken. Okay. All right, so I will entertain. In fact, I need you to say it again, because so we're not reaffirming the vote that we took back on whatever it was. I'm confused on it. Say it again.
So you're reaffirming the decision as modified that evening. So the complaint is that the modification, the discussion that led to that modification, should have occurred at a meeting at which, or prior to which, an agenda was posted specifying that there would be discussion of the 23 Washington Avenue proceedings that occurred a week earlier. There was no specific reference on the agenda to that project or that decision, because I believe the intention was simply for the board to show up and to sign it, since they'd be gathered together anyway for one of their usual meetings. So you're simply reaffirming that the decision, as amended and as signed that night, is consistent with the will of the board.
Okay.
And the people that would be reaffirming are the three signatories to that decision,
That's correct.
which I think was Brian. Yeah.
Okay. So I will entertain that motion if someone wants to belt it out.
I move that we reaffirm the decision on 23 Washington Street as amended on the April 11th meeting, and that the three signatories to that decision so state tonight.
I second that motion.
All in favor, say aye.
Aye.
Any opposed? And just for clarification, the three members who signed it are present?
Yes.
Okay.
Okay, and I would ask for a second motion, if I could, Mr. Chairman, just to approve, if the board sees fit to do so, the open meeting law response, which I will submit tomorrow. We have received an extension, notwithstanding what I said before about the effort to get these done within 14 business days, you weren't meeting quickly enough for that to occur. So I think the 14th business day was maybe yesterday. So we've got an extension through the week so that we can make this submittal tomorrow if the board gives me permission to do so.
All right, so I'll make a motion to approve town council's response to the open meeting law complaint.
I second that.
All in favor? Say
Aye.
Aye. Opposed? Abstained?
Thank you.
Okay, great. Okay, thank you, Adam. So we're running a little behind, but we're gonna start with our first hearing for the evening. And I will read it from the agenda. Claudio A. Alves, owner has applied for a special permit under Chapter 282, Sections 7.6 and 9.3 of the Ashland bylaws to allow for the use of the second floor as an accessory family dwelling unit. The property is located at 366 Elliott Street in the Residential A zoning district. Public hearing will be held on May 9th, 2017 at 7:05 PM in the Board of Selectmen's room located at Town Hall. Okay, so we'll officially call that hearing to order. And who's here for the applicant? Come on up. You just come to the podium, just give us a little overview of your project. Just get that one out. And just state your name and your address.
Yes, my name is Claudio Alves, and I live in 366 Elliott Street, Ashland. I bought the house in January, and I refurbished the upstairs apartment. I asked for a permit. I came here to ask for a permit for plumbing, some electrical work, and in that apartment was an existing stove, so 2 stoves in the house. I've been told that I'm sorry, my English.
No, that's fine. You're doing great.
There cannot be 2 stoves in the house, and but I just bought the house in the way that it is. I didn't put the stoves over there, and I just tried to use the apartment in the way that it is.
And, okay, and did you talk to the building inspector? Who directed you to us?
Adam? I'm sorry.
Josh.
Josh, I'm sorry.
Okay. Okay. Great.
Josh helped me too much in fill up the application and explain me a little bit,
Okay.
what to do
Great.
and being here.
Okay, and has everyone had a chance to review the application?
I have.
Questions for the applicant?
There's been no exterior change proposed to the house, is that right?
Right, no changes.
And does the second floor have a separate entrance?
Yes.
Okay. Is the house have a septic system, or is it on town sewage?
It has a septic system until today. Today we attach the sewer.
I'm sorry, today you
Today it's been attached to the sewer line.
to the sewer line,
To the
okay.
sewer line, yes.
So that solves that problem.
Just run through that.
I think we have some more questions.
And how large is the accessory unit in square feet?
It's a little bit more than 500 square.
Just over 500 square feet, so.
Okay, so that would fit.
So 767, such accessory unit shall be limited to a maximum of 25% in floor area of the principal residence, or 800 square feet, whichever is greater. So I think that's in excess of the 25, but it's less than the 800, so it falls within that. Parking, off-street parking for dwellings. You have enough, how many parking spaces do you have?
6,
Okay,
And how many cars are there
3.
now? And how many?
3.
3 cars.
3 cars.
Okay.
And that's what's proposed if the second floor is occupied as a,
One,
One.
that's, yeah, it's my daughter.
going through the requirements here quickly. While I'm going through the specific ones, do you have the general 5 or 6 you want to run through?
Well, in order to grant the special permit, amongst the items we have to consider is that the adverse effects of the proposed use will not outweigh its beneficial impacts to the town or the neighborhood in view of the particular characteristics of the site and of the proposal in relation to that site. And then there are certain specific factors that we need to consider. And the first one would be community needs served by the proposal. It's my understanding that it's your daughter and grandchild that will
Yes.
be moving in?
Yes.
Traffic flow and safety, including parking and loading. I've driven by the unit, the home. The cars will be parked how close to the roadway? Approximately.
I'm sorry, how close to?
When the cars come in, they come into the driveway.
Yes.
Is it outdoor parking as opposed to parking in a garage?
It's outdoor parking.
Outdoor
And
parking.
it's one car garage also.
One car in the garage. And how far from the roadway are the cars, the outdoor?
In?
Yeah, how far in?
6 feet, 7 feet, 7 foot.
Is that consistent with other houses in the neighborhood?
Yes.
Third item will be adequacy of utilities and other public services. Does the apartment on the second floor have its own electrical billing, or will have its own electrical billing, or is it all
It's all in 1 meter.
all in one? Okay.
That's fine.
Yeah. Neighborhood character and social structures. It would appear to be a neighborhood of single-family homes on a fairly busy street, if I may characterize it as that. Are there any other houses in the neighborhood, if you know, that have 2 families living with them, or a rental unit with 2 families in it?
To be honest, no. I don't know.
Fair enough. Impacts on the natural environment. There aren't going to be any changes made to the immediate outside territory?
No.
Okay. And potential fiscal impact, including impact on town services, tax base, and employment.
Minimal.
Minimal
Yeah.
on all scores, I would think.
Yeah. Okay. Any other questions, observations before we open it up to the public?
If I may, Chairman, what was the upstairs used for before you did the renovation? Was it just like an attic space, or what was there?
Oh, no. It was like a kitchenette. It was
was a
already
kitchen, okay.
existent
It was, okay,
when I bought it, yes.
okay.
I have pictures. I don't know if it's...
Stu, anything?
No.
Okay, so we're gonna open it up to the public to see if anyone else wants to comment. So
Okay.
just have a seat and we'll see if anybody else has any comments.
Thank you.
I think you know the drill, but just state your name and your address.
Cliff Wilson, 378 Elliott Street.
Yeah.
I live 2 houses down from Mr. Alvis. There are other properties in the neighborhood that are rental units are on the other side of the street, but they do exist, just to let you know that. I have absolutely no objection to this proposal. Just wanted to, fill you in on that there are other rental units in the neighborhood.
Okay, great. And anyone else? All right. I know we don't usually vote, but this one seems pretty straightforward.
It is, do we need to decide?
We need to
who's
decide who's gonna sit
sit?
on it, yeah. Is anybody not, this is an easy one, you want a tough one?
Take them all, whatever.
Yeah.
Whatever.
All right, how about you, me, and Stu? You good? Yeah,
That's fine.
I'm gonna give you a tough one.
No, I don't mind sitting this one out.
Okay, so discussion? It seems to hit all the criteria.
Yeah, everything seems fine with me. I don't, doesn't seem like there's a problem. He bought a house, has an apartment in it, didn't realize it's not permitted. Doing the right thing, getting a permit.
Yeah, that's
That's what I see.
the policy behind the bylaw, so. Stu, anything?
No, I concur with Diane's assessment.
Okay. Then anybody want to make a motion to approve?
I would make a motion to approve the special permit.
I'll second. All in favor? Aye. Opposed? Abstain? And that, well, the 3 voting members, yeah.
Should we place some conditions on the approval, just as we normally do with in-law apartments as it is, and basically just mimic the, or not mimic, but restate certain of the provisions, namely that it has to be limited to a
Family
relative,
member, yeah.
a family member. 7.6.3 indicates that the additional family living unit shall be limited to a maximum of 4 people, provided that the owner of record is an occupier of the structure, and that no boarders or lodgers shall be allowed in either dwelling unit.
It's a good question. We have town council here, might as well ask them. My understanding is if you violate that, you can have your permit essentially rescinded, but should we throw that in the decision anyway?
So as a general rule, if a decision issues for a specific use permitted by your bylaw, then any requirements associated with that use that are already contained in the bylaw would apply. The only confusion arises when a permit issues, say today, and your bylaw changes in the future. So I think that there is some basis for, and it may be the prudent thing to do, to reiterate the provisions of the bylaw that you believe are restrictive of the use as part of your decision, so that it's clear in the future what your intention was with respect to granting the permit. Certainly if the bylaw were to change in the future to become more liberal and to allow something greater to occur, the applicant could seek to modify its permit. But if the bylaw changes to become more restrictive, having those details in your decision makes it clear what is and is not allowed, and it may be something more than what is allowed in the future.
Okay. Anybody want to volunteer to draft this one? Bueller?
I mean,
Oh, that's
if
right.
I can, I mean,
I always forget now.
I mean,
Good. Yeah.
kind of my job.
Yeah, that's, and I
suppose.
don't want to take
We're
away
not
your
used to
reason for
having
being.
such good
Yeah.
support.
Well, yeah,
All right, so I don't think we need to revote, but when you draft the decision, I guess if you could just incorporate
yeah.
the underlying.
Yeah.
And we did do
requirements.
allow a special permit a couple of years ago under the same bylaw, and I can email you that as a template if that helps.
Yeah, yeah, sure.
All right, you're all set. Thank you for coming in.
That's it.
All right, so let's just get organized here. Okay, so the next hearing, Russell and Mary Pollard, owners have applied for a special permit under Chapter 282, Section 3.3.5C and 9-3 of the Ashland bylaws to construct a 631 square foot addition to a pre-existing non-conforming structure. This proposed addition will be 14.2 feet from the front lot line, which will encroach upon the 30-foot front setback. The applicant plans to file an application to combine these two adjacent lots in the future. The property is located at 35 and 37 Lakeside Drive in the Residential B zoning district. public hearing will be held on May 9th, 2017 at 7:20 PM at the Board of Selectmen's room located in Ashland Town Hall. All right. Mr. Efford.
Good evening, Mr. Chairman, members of the board, fellow citizens of the town of Ashland. I'm fortunate enough tonight to represent Russ and Mary Pollard in their second attempt for a special permit in connection with their property at 35 Lakeside Drive. They already have a special permit that they secured from this board in 2005 in connection with an addition that they then constructed upon their property. This case is a little bit different, but it triggers really the same request for relief. They propose to put an addition on their property, a 28 by 24 single-story addition to the existing property that has already been once approved. They're doing that by essentially going to ask the board to allow for a further encroachment of the front setback. They'll be doing that by utilizing the property that they own adjacent to this property at 37 Lakeside, which, if the board sees fit to approve this, will be asking as one of the conditions that they go to that you make them go to the planning board to get an A&R to cease having that as a separate lot. So, as an alternative to rebuilding on that property, which was partially destroyed by a fire in 2015, they are seeking to forget that use and essentially expand this particular property. This relief triggers section 3.35C of the Ashland zoning bylaw, a bylaw that we talked a little bit about in a different context under a zoning appeal. And as we stated, and then we had the benefit of town council that night to actually educate all of us about that bylaw, it's part of your non-conforming use bylaw that pertains only to the redevelopment, alteration, or extensions or modifications of non-conforming single and two-family structures. This is a single non-conforming structure, having been built before the adoption of the Ashland zoning bylaw. It is non-conforming by virtue of area, and it is non-conforming by virtue of violation of the front setback. The proposed addition will increase the nonconformity, but only in the front setback area, but it will do so in a manner that is not more nonconforming. Accordingly, under your bylaw, we do not need a variance. It's under 3.34. We think we're in the right place, and we're thinking we're asking for the right relief. We believe that relief is appropriate for the following reasons. Number one, by doing this, we're going to be essentially lessening the congestion in the neighborhood, because instead of 2 homes that can be utilized, we're only going to have 1. Instead of locating this particular addition backwards to stay out of the front setback, which would encroach on wetlands and be too close to the water, we're staying out of that area. We're also basically doing a relatively small, benign addition. The square footage of the addition has been certified by an architect. You'll see that as part of your filing. That certification shows that the total square footage of the proposed project with the addition will be 1,932 square feet. Again, with reference to the zoning bylaw, that is less than the 4,500 square feet that would trigger a need for a separate and distinct special permit under another provision of your bylaw. This is a fairly non-intrusive addition. It's really, I'm going to try to phrase this carefully by representing what the Pollards told me. They're getting up near my age, and it's easier for them to have more living space on the first floor. And as a result, they want to do this addition as opposed to trying to do something, an alternative. They've been living in Ashland for quite a long time. They certainly want to continue to make their home here, and they believe that it fits in with the character of the neighborhood. It is not offensive. It is simply an extension of their non-conforming use. It needs to be conditioned on the permanent eradication of the boundary line of the other property, the forfeiture of their rights that would go with that particular property. We would hope we've given you enough information, and we would hope for your favorable consideration. Thank you. I hope you have in your package, I don't know, there was a letter of support from the direct abutters. Do you have that?
Yes.
Thank you.
Yeah.
Oh, you might as well stay up there, Jerry. We'll probably have 1 or 2 questions. Or maybe, and let's say, so sitting on this, 2 of you guys want to sit? And then
Sure.
Stu, 1 more?
Sure.
Just for fun? Okay. Questions for Attorney Efron?
Is there anything that you need to go before the Conservation Commission for with this plan?
No, and in fact, if you take a look at the proposed conditions planned by Metro West Engineering, they located the structure in such a manner as to not do that. And in fact, the engineer consulted with your conservation agent in designing the proposed addition and locating exactly where we were. So we might have been able to do something that wouldn't have offended the setback, but it would have been environmentally more sensitive, and we didn't go in that direction.
All right, I'm glad town council happens to be here, because I saw it in your packet, an old decision, which I happened to sign many years
Yeah, we're getting
back.
old, aren't we?
I know.
Yeah.
But the reason you're not exasperating the existing non-conforming setback appears to be based on that old decision. It looks like you added to the front of the house quite a bit back in 2005, and I have to admit, I don't remember the case at the time. The bylaw has changed since then.
Right.
I mean, that decision 2005, I don't think would have been allowed today. You could, but, so my question.
That's probably not important.
That's why I want to ask town council. So, does it make a difference now? Does that still count as pre-existing non-conforming, even though it was by special permit after the bylaws were enacted?
Well, I'm going to do something that I don't like to do, which is I'm going to answer without all the facts, because I have not. I'm obviously here by pure coincidence on other matters, so I've not reviewed the application. I've not reviewed the plans. I'm looking over the shoulder of a member to see them.
I'll show you what I'm talking
Sure.
about. So that's the plan from the old one in '05. So here's the existing structure.
Mhm.
They bump it forward, which I think that would have taken a variance today rather than a special permit. But, and so now they're 13.3 because of that special permit. And everything else I think is fine. And so now the new structure is going to be 14, which is not any worse than that, but only because of the special permit back in '05.
Right. So the general rule, and again, without reviewing the decision that was issued back in '05, it's hard to say only looking at the plan, but the general rule is that when you receive a variance to authorize a particular structure or use, that
was a special
no, I
permit.
understood. But
Okay,
whether it's a variance
okay.
or special permit, if you receive a variance for a particular use or structure and you later make changes, you need to modify your variance. You can't then claim that by virtue of being out of compliance with the bylaw, you are therefore a non-conforming use or structure. You're non-conforming if you were legal at the time of creation, and something that's authorized by a variance is not. Now, this is a special permit. I think the same rationale would apply, that if what is authorized, what exists today was authorized by way of a special permit, then it's not a pre-existing non-conforming structure because it wasn't lawful when commenced. It was simply authorized by way of a special permit. So you need to go about amending the special permit. Now, I think that's essentially what the application is before you. Is it not a request for a special permit?
Mm-hmm.
Yes.
I think it's been cast in a slightly different light by the applicant in terms of the manner of application, but based upon what I see here, I don't see why what's being proposed can't be done by way of a special permit if there's no intensification of, well, I guess it's not a nonconformity, is it? So the special permit that's being sought is for purpose of the nonconformity. I need to see the decision that was issued in '05 because it sounds like the decision in '05 was not a nonconformity special permit, or was it?
Under the prior bylaw,
Okay.
the pre-09 recodification, which I have no recollection of what that one said. Let's assume this was issued correctly.
Sure. So if it were issued previously as a special permit authorizing the expansion of a nonconformity, then certainly today's bylaw provisions would apply to changes to it.
Mm-hmm.
But you could still modify it so long as you're not in violation of the restrictions in today's bylaw. So today's bylaw says, with respect to nonconformities, that some are authorized only by way of a variance, and others, if they're to single or two-family structures, can occur either by way of approval from your building inspector or by way of a special permit issued by your board. So the distinction between the two, and I think Attorney Efron spoke to it briefly, was a variance is required in circumstances where the existing nonconformity is increased or a new nonconformity is added. If either of those things are occurring here, and I don't have the current development plans in front of me to compare, but if either of those things are occurring, a variance would be required. But if all that's occurring is one of the other various things that are described in section 3.3.5 that can be done by way of a special permit, then it would be within your jurisdiction to grant that special permit if you see fit.
Great. Because, I mean, here's the decision, but it's got nothing in it. I mean, it's got.
No offense.
No. I didn't write it.
It's a great decision.
Oh, yeah.
And the other thing is, for whatever it's worth, as we know, it's
Yeah.
over 10 years old, so
Yeah.
it's kind of locked in.
Good. I mean, I just want to. I think it's a great project. So, any other questions before we open it up? Okay. Anyone from the public like to speak on this one? I know we got some correspondence in support. Yep, please.
Hi, how you doing?
Good.
Tony Lewis, 34 Washington Ave. I'm in support of the Pollard's request, and it probably affects me more than anybody else, because we look outside of our kitchen window and we see the lake. Now our view has been changed, but it's a small addition, it's a small change. It's still consistent with the character of the neighborhood, and and they communicated with us to check to see what we thought of it. So I appreciate it, and I think go ahead with it. Gets my vote.
All right, thank you. Anyone else? Okay. Discussion?
Go through the,
We should go through the, yeah.
I just have to find it.
And Attorney Efron's, submittal goes through them as well, but you want to do the honors?
If you want, well, once again, under 9.3.2, granting a special permits, we need to make a written determination, finding that the adverse effects of the proposed use will not outweigh its beneficial impacts to the town or the neighborhood in view of the particular characteristics of the site and of the proposal in relation to that site. And in addition to any specific factors, we shall include consideration of each of the following items. 1, community needs served by the proposal. I would suggest that allowing the applicant to make the proposed changes to continue to reside in their home of long-standing in a neighborhood that certainly has unique characteristics is something that the town of Ashland should support, and that it would support the community. All of us of advancing years can appreciate the desire to not go up and down stairs every morning.
And it sounds like, so the existing structure, is it still saying that was damaged by fire? Is that still saying, does that need to be taken down?
37.
37.
35. The changes are.
Well, no, I understand. So, but the other one, does that need to be bulldozed still?
It will
And-
be.
All right, so
Will
you'll
have to
actually
be.
be cleaning up
Yes.
the neighborhood as well. Okay.
Traffic flow and safety, including parking and loading, would not appear to be any change whatsoever.
Right.
Adequacy of utilities and other public services, again, wouldn't seem to be any. Neighborhood character and social structures. My review of the neighborhood in the drive-by, it's a unique neighborhood, and certainly the changes proposed would be in keeping with the neighborhood. There are some very large, relatively new appearing houses in that neighborhood that have replaced obviously smaller homes. It would seem perfectly in keeping with that.
And the neighbors who have spoken have been in support.
Supportive of it,
Yep.
which speaks well of the applicant. Impacts on the natural environment would not appear to be any impact
Well,
on
and
the
as
environment.
Attorney Efron stated,
So perhaps an improvement.
they kept out of the 25 no disturb zone, out of the wetlands, which we appreciate.
Potential fiscal impact, including impact on town services, tax base, and employment. Obviously, some short-term construction employment. No significant increase in town services, and probably a slightly larger tax bill from the town of Ashland, I would guess. Perhaps offset by the reduction in no tax bill for 37. Anybody else have anything to
add to that?
add to that?
So conditions, I mean, obviously we need to condition upon the A&R being submitted and the lots combined. Any other?
When would that be proposed, that application for the A&R?
When are you gonna combine the lots?
As soon as this decision is final and hopefully nobody appeals it.
Okay. So,
The A&R
are
plan-
the-
I'm-
yeah, go
I
ahead.
shouldn't be doing this.
No, you know the truth, yeah.
Sorry. The A&R plan is prepared, but it would have been premature to file that without the discretionary relief here. So as soon as that discretionary relief is given, hopefully, and it's finalized, we'll get on the agenda at the planning board, file the A&R plan.
What time frame do you think that would take?
I don't know when you're going to write and file your decision.
Well,
but
I mean, assuming once the decision is done, the 20-day appeal period is filed.
We'll
how
get
long
on,
do you
we'll try to
think
get on to the
going
next
through the
next planning board that would
process?
have an open spot on the agenda.
Okay.
Okay.
Would it be appropriate to put a condition as far as a time frame in which those items should be, need to be filed?
Most respectfully, I'd ask that you put a condition that those things be done before an application for a building permit is filed in this
Well,
case.
that's exactly it.
Yeah.
So no building
Okay.
permit until the A&R has been approved. Yeah. And Josh, you got that, right?
Mhm.
Yeah. Any other conditions?
So that was my,
Yeah.
that was my question.
Yeah, that was mine too. When can we combine them?
Okay. I guess we'll vote again.
Okay. All those in favor of granting the request for special permit, subject to the conditions that we have enumerated, say aye. Aye.
Aye.
Opposed? Abstained?
All right,
3-0.
excellent. Okay,
Thank you very much.
thank you. All right, it is, well, we're almost back on schedule, 10 of 8. Let's everyone get organized for the next one. What's this one?
Yes. This little minor matter.
That's this. You guys, everyone organized? Yeah. All right, so the third hearing this evening, public hearing will be held on Tuesday, May 9th, 2017 at 7:40 PM in the Board of Selectmen's Room, Ashland Town Hall, 101 Main Street, Ashland, Mass. For consideration by the Zoning Board of Appeals of modifications to a comprehensive permit issued to Capital Group Properties dated October 6th, 2016, under MGL Chapter 40B, Sections 20 to 23, for a 7.62 acre property located at 133 West Union Street in the Residence A zoning district. The public hearing is to be conducted pursuant to an order of remand issued by the Housing Appeals Court, Housing Appeals Committee in HAC case number 2016-17. Modifications requested include reconsideration of the board's denial or partial denial of waivers from section 4.1.1 and 5.1.2 of the zoning bylaw, namely the table of dimensional requirements and schedule of parking area requirements respectively, to permit the development of a 120-unit multifamily housing project with pertinent parking and other amenities, reconfigured as depicted in preliminary plans on file with the board, and available for inspection at the Community Development Office in Town Hall during normal business hours. Parties wishing to be heard should appear at the date and time in the location stated above. All right, so I'll call this hearing to order. And I'm going to turn it over to Town Council in a moment here, so to go through this. But so we issued a decision, and I don't remember the date that we issued the decision. Actually, is a while back. We've had hearings on this for about 2.5 years. Issued the decision on the 40B allowing 99 units with a number of different conditions. That was appealed to the HAC, Housing Appeals Committee. As part of that process, there's mandatory mediation that goes on, and a number of us took part in that remediation. I think myself and John were there for about an hour or so in the beginning, hour and a half,
Right,
and then
we left.
we had to leave. Town council was there for the entire meeting. I think Stu was there for the entire
Brian
meeting,
was there,
and Brian was
Stan Dana was there.
and Stan. And we'll go into the details. I'll turn it over to town council to sort of go into the details of what came out of that mediation. But as part of that process, then, sort of a mediated settlement was reached, subject to vote of this, public hearing and vote of this board. And that is what is going on tonight. So we're going to discuss. So nothing's been settled. We have a proposed mediated settlement, which we'll now discuss and either vote up or down. So that's sort of the bird's eye view of what's going on. I'll let town council get into the nitty-gritty of it.
Okay, thank you, Mr. Chairman, members of the board, and members of the public. So I may reiterate a bit of what you said, Mr. Chairman, sure. But I think it's beneficial that we remind ourselves of where we've been with this project and familiarize ourselves with where we are today. And I'm not going to get into the substance of the modification before you. Attorney Catanzaro is here on behalf of the applicant, and he'll touch upon the proposed modification momentarily. So as the chairman noted, this was a project that came before the board for the first time in mid-2014 and underwent a review over a period of about 2 years, over 2 years. And on October 6th of 2016, the board reached a decision unanimously to grant the comprehensive permit under Chapter 40B of Mass General Laws. Chapter 40B is a bit different than Chapter 40A, a bit different than special permits and variances and other forms of relief that zoning boards of appeal are most familiar with. It's a state statute. Legislature has prescribed a need for affordable housing and has placed a heavy burden on municipalities to approve of projects that allow for affordable housing. And in doing so, has given developers the opportunity to seek waivers from what would otherwise be required zoning bylaw, general bylaw standards. And so that's exactly what came before the board, a request to construct a project that would be certainly more dense than what would be permitted pursuant to the underlying zoning, with a variety of other waivers from dimensional requirements, et cetera, of your zoning bylaws, as well as your general bylaws, including your wetlands bylaw. So in the board's decision of October 6, 2016, it granted the permit, but it granted it with a variety of conditions. In fact, I have a copy of the decision before me, and the decision itself is over 20 pages long. Two of the most notable conditions, maybe one more notable than the other, was a restriction on the height of the building. The height requirement, or the maximum height, in the district is 35 feet according to your zoning bylaw. The request for a waiver was for a height of 56 feet. And in the board's decision, the board allowed for a waiver of the height, but not up to a maximum height of 56 feet, up to a height of 46 feet, allowing essentially for 3-story as opposed to 4-story structures. And in accordance with that requirement or partial waiver, also modified the parking requirements or parking that had been proposed by the applicant. And that's what went into the October 6, 2016 decision. It did that in part based upon information that was provided during the public hearing by various consultants that were engaged by the board on the developer's dime, but nevertheless who worked for the board, and who provided information concerning everything from the engineering of the site to the economics of the project, which is something that can be considered under Chapter 40B. And the decision to, and I don't want to speak for the board, but certainly I was present at the deliberations, I understand that the decision to require 3 stories as opposed to permit 4 stories was based in part upon a determination made, an opinion given by the board's financial consultant that a 3-story project would be financially feasible and would be economic for the developer, which is a standard under 40B. A board can't impose conditions or refuse to grant rate waivers that would render a project uneconomic unless it can prove that there are local needs, which are very limited under the law, that trump the need for affordable housing. So that's what gave way to the October 6th decision. The applicant appealed that decision to the Housing Appeals Committee. Housing Appeals Committee is a state administrative agency. It's a department within the Department of Housing and Community Development. And the Housing Appeals Committee, or HAC, reviews developer appeals of either 40B denials or 40B approvals with conditions. And so that's what the developer requested. And as the chairman noted, as a component of that process, there is required mediation, which differs a bit from courts in Massachusetts, where courts cannot require mediation, the Housing Appeals Committee can. So we had a mediation session that was scheduled for January 30th. It began at 9 in the morning, I believe, and we went for the better part of the day. I think we wrapped up just after 4 o'clock. So it was a lengthy mediation session. Mediation was held in executive session of the Zoning Board of Appeals, which is permitted under the open meeting law, very explicit exception for mediation. And during that mediation, a variety of things were discussed. I'm not going to get into the details because it was an executive session. But the things that were discussed primarily, as had been discussed to some degree during the deliberations of the board, was the standard to which the board will be held if it's required to continue to litigate the case, to defend its decision at the Housing Appeals Committee, and potentially beyond if there's further appeals to the Massachusetts courts. And again, the 2 standards here that needed to be considered was, number 1, the economics of the project, and number 2, whether there were local needs that trumped the presumptive need for affordable housing in the town of Ashland, in your county, and generally in the state of Massachusetts. So as a consequence of a day's worth of deliberations and different discussions with the applicant about various iterations of the project that might be different from what was approved, but also different from what was proposed. You might remember that originally the project proposed 140 units. It was reduced to 132 units about halfway through the process. And then ultimately the decision that was rendered that cut down the height of the buildings from 4 to 3 stories effectively reduced the number of units to 99. So discussions were had and a potential mediated resolution, and I say potential only in the sense that certainly the board gave its a consensus among its members, those who were present through the mediation, that it was supportive of this approach, subject to a remand tonight, was that the project would be modified such that the setback of building A would be increased and the overall number of units approved would be decreased from what was originally approved, but originally proposed, but certainly increased from what was ultimately approved. And that's what Attorney Catanzaro is going to discuss in greater detail momentarily. So the board reached that consensus during the mediation, but as is the case with any project of this sort, whether it's a Chapter 40B project or a Chapter 40A project, there's a public hearing process that gave rise to the original decision. So certainly any modification of that decision has to be subject to that same process. And those were caveats that I made very clear from my initial discussions with both the Housing Appeals Committee staff as well as the mediator, that any resolution that was potentially reached in mediation would be subject to a request to the Housing Appeals Committee that the matter be remanded to the Zoning Board of Appeals for noticing and conducting of a new public hearing to discuss not the project as a whole, but simply the modifications that were potentially agreed upon in mediation. So with that, I'll turn it back to you, Mr. Chairman. Again, I think the applicant will discuss the modifications, and then certainly I'm happy to answer any questions that you or members of the public might have about the process or about the task that's now at hand.
Great, thanks, Adam. Before we turn it over to Attorney Catanzaro, does anyone have any questions for Town Council? Okay.
Good. Briefly, before we address the proposed changes to the project as a result of the settlement, I do want to make a couple of comments about the process. As everyone probably knows, and as Adam just pointed out, okay, on January 30th, we appeared before a mandated mediation session in this building, and it lasted, as Adam pointed out, the better part of 6 or 7 hours. Even though the mediation was mandated, certainly the settlement was not mandated. And we proceeded And I think, like everybody in the room, proceeded on the good faith understanding that if we did reach an agreement, that there would be a likelihood that the members of the ZBA who participated in that process would be standing behind that recommendation. In fact, so that the record is clear, the very proposal which was finally acted upon was one that was presented to us. We went there that day pretty much set that we did not want to diminish or reduce the density. But when the board made its proposal, which we felt was reasonable given all of the circumstances, okay, we decided that, yes, well, the board is reacting in a way, in an appropriate manner. And as a result of several more hours of discussion, okay, the mediated settlement was reached. Now, the appeal to the HAC was not the only appeal of this comprehensive permit. Okay, 6 abutters, Mr. and Mrs. Hicks, Mr. Arminio, Mr. Aynan, Mr. Blasavage, and Mr. Musker also appealed. They also sued us and the town in Superior Court, okay, challenging the comprehensive permit. They filed a motion to intervene in the Housing Appeals Committee process, and even though that motion was never acted upon, they also were allowed to participate in the mediation, because I think everybody felt that if we weren't going to have a global resolution, then there wasn't sense of having a settlement at all. And as a result of that mediation, we also reached a settlement with the abutters. We have a confidentiality agreement, and I don't think that the terms of that settlement are important, but in principle, we have reached a settlement with them. The settlement with the town was not contingent upon the settlement with the abutters, and so we have 2 separate things going forward. Now, in order to get to here tonight, one of the things that we had to do was the town and the developer had to file a joint motion for remand. And that joint motion for remand basically asked the Housing Appeals Committee to remand this matter, this mediated settlement, okay, and that's the language that we used in the motion, okay, to this board for consideration. Now, we understood, as Attorney Costa pointed out, that regardless of the fact that there was a settlement in principle, that it still would require this board at a public hearing to finally endorse the settlement. But I won't say that I thought that that process was going to be pro forma, that it was going to be a rubber stamp, because I knew that the public had a right to comment, and as we have learned, many people have commented on the settlement. But there is a certain amount of, I think, integrity behind the settlement process that now here we are almost 90 days later. Okay, we could have been through most of the HAC process already, and we're standing here, I guess, with a lot of opposition to something that this board pretty much told us that they were in agreement with. Now, I'm not going to get into the merits, and we are going to present our revisions, which all of this information has been previously presented to you. We provided the revised plans in March. Okay, we provided, there was a letter on April 10th from the, I believe, the town planner. We responded to that letter. We prepared and proposed a draft comprehensive permit, a revised comprehensive permit that addressed all of these issues. And we essentially have gotten no feedback from the town or this board at all for the past almost 90 days, other than reading the newspapers and being told that now there's this opposition to this settlement. So after we make our presentation, I think it's important that this board just keep in mind that you are the zoning board. The Board of Selectmen are not the zoning board. You are statutorily charged with the responsibility, okay, of issuing and standing behind your decisions. You made a decision. And I'm going to suggest to you that the reason that you decided on the mediation is because there is a significant chance, and in fact, I think that it's a very good chance, that the project that's going to be approved, if it's not settled, is the 132-unit project. There have been public statements made that the 99-unit project is economic. Well, it is not. Okay? And under the standards that are applied by the state in the Housing Appeals Committee, okay, this project is woefully uneconomic. And what's going to happen if we don't settle, and we were willing to settle. I mean, 12 units might not sound like a lot, but it's a lot to a developer who's going to be spending tens of millions of dollars building a project, okay? And we compromised. And the project that I gather that you want, I don't think is going to hold muster before the HAC. I also read of promises that you would continue to litigate. We do this, I do this for a living. I mean, continuing to litigate this case will probably just help me pay for my grandson's college education. But it's not going to change the project, okay? And so, and I think, okay, and I think that this is why you did it to begin with, because you understood that. So now I'd like to just turn it over to our engineers. He's going to just go over briefly those changes that we made. I would remind the board, and I think Adam agrees, that under the remand, the only thing that's up for consideration tonight are those changes. Okay, we don't have to revet the entire process. And at the end of the night, it's either you stand up by your settlement or you don't. And whichever way it falls, that's the way that it falls.
And just before you jump in, just we're definitely going to open it up to the public. So, but before that, if you could just, you know, keep it down so we can just hear them, and then and everyone is going to get a chance to speak.
So if Peter can set up his easel, he'll go over the changes that were made to the plans.
Over here, would you let me put over here?
Yeah. Take it away.
Good evening. My name's Peter Lavoie. I'm the civil engineer for this project, and I'm with Garrier and Hellnon. So, like Angelo said, I'm just going to go through the changes from the approved plan, which is on the bottom, and then this is the revised one on the top. So, what we did is we reduced building A in length from 225 to 193 feet. By doing that, we pulled the front of the building, which was only 27 feet off the front yard setback. Well, it was 34 feet off the front property line, and now it's 82 feet. So we doubled the distance off the front property line. Also, by reducing the footprint, we increased the side setback from 27 feet, which it was, and now it's 47 feet. So we increased that 20 feet from that side property line. By moving the building back away from the front and the street, we also reduced the impervious area here by removing roughly 10 spaces. So now we have a total of 221 parking spaces. We had 231 originally. By doing that, you decrease the impervious area of the project, but the drainage study did not change, so it stayed with the higher impervious area. So basically, the approved drainage design is now over-designed for the project because we decreased the pavement roughly around 6,300 square feet in size. So,
do you need the parking waiver again? Are you under, what is it, 2 to 1?
I'm not sure. Do we need the parking waiver?
I'm pretty sure that I did request it in the draft, but I'm not positive.
Well, is that it's 2 to 1 per unit, 2 spaces per unit, right?
Yeah, we have 220, so we would be below.
And you need the 240, right?
We would need the waiver.
Okay.
Okay. And then by reducing the pavement, it just extended the emergency access, so we still keep the emergency access. And then we revised the landscaping along the street and added additional landscaping. Also, by reducing the footprint size Basically, we added more snow storage in the front of the building here, which we had less before. So basically, that is the only change, was this area right here on building A. That was the only change to the plan.
From the 132 plan.
Correct, from the
Yeah.
132 plan. Everything else is the same.
The building would be 4 stories high and not 3, correct?
Correct.
Okay.
At a height of 46 feet, was it?
No, 56.
56 feet.
56 feet.
The actual, the requested waiver is 56 feet. The actual construction height of the roof line is probably going to be somewhat under 55 feet. Okay, so, but we kept the waiver request at 56.
Yeah.
Because we're still, some design room to move it.
That's basically the changes, the site changes to the plan.
And then I know town staff had sent you some requests. I thought those were addressed. It was like 8 or 9 of them. I thought I saw something that said it was, see revised plan. I just was hoping he'd run through those. So, letter date April 10
Copy of it.
from Sheila.
Angelo will address that.
Okay.
Yeah, to the extent, we may have to collaborate here, Peter, but
Sure.
I have their letter, and our project manager did file a written response to that letter. We received the letter on April 10th. We responded that same day because at that moment, we thought that we were still on for April 11th. And then we were later informed that afternoon that there was that mix-up with the with the scheduling of the hearing. So if you want me to go through each one?
Yeah, if
Okay.
you wouldn't mind.
The April 10th letter from Ms. Page, first request was the parking spaces adjacent to Building B and by the entrance are within the 80-foot setback. And our response is that the parking spaces across from Building A are within the 80-foot setback because the clubhouse is in an existing building and the parking is for the clubhouse. There's only one spot with an 80-foot setback, and it is handicap spot for the clubhouse. So I gather that the issue or the concern was that we were going to have an 80-foot complete setback, but we're showing one handicap parking space for that, and we needed to do that so it could accommodate the clubhouse. Second comment was the trash receptacle should not be in the 80-foot setback, nor should the emergency access be used for trash pickup or dumpster servicing. And the response is that is not a trash receptacle. Do you know what
It's a transformer pad.
Okay, yeah, it's a transformer pad, and the emergency access will not be used for trash pickup.
Do you
Can you
mind
show-
just pointing those out? Just
So the proposed transformer pad is in this location here.
okay.
That's where the pavement used to be.
Yeah.
So when we moved it back, we just kept the transformer pad there, and then this handicap spot right there. There's 2 handicap spots adjacent to the clubhouse, and that first handicap spot is right on the 80-foot setback.
And is there a reason that transformer needs to be there? I'm not saying I have a huge problem with it, just
No, I
curious
mean-
why you didn't move it.
No, we just left it there, and because that was I just left it there because it was approved there before.
Okay,
I mean, it's really not too. It shouldn't be too high. So
okay.
The third comment was to augment the open space. It is suggested that a few more native trees such as oak, white pine, or maple be planted as a buffer between Building B and West Union Street. We have provided the board with a revised plan, and we would obviously be accepted. And there's the revised, Peter, if you could put that up, landscape plan, and which identifies the species. And we would we would obviously accommodate any reasonable request for the kinds of trees that the board would prefer.
that's basically in this area here.
So are you clearing all those and then replanting?
Now, there are trees that are currently there that we are showing as remaining. We're leaving that up to the board's discretion. You know, our view might be that it might be more appropriate to take down some of those trees and replace them, but right now, they're shown as remaining on the plan.
Okay.
Because that was our understanding, is that what the board wanted. A plan set with changes, bubbled, and a narrative which includes an affidavit signed and stamped by the engineer stating that the highlighted changes are the only changes from the approved plans set should be submitted.
That's fine.
Okay. And we provided that.
Yeah.
The snow storage should not be in the same location as the irrigation well because of concerns that a plow could damage the wellhead. Bollards protecting the irrigation well are suggested. The plan has been revised, and can you
Correct.
show that?
Well, the snow storage was moved further away from, so the wellhead is all the way up near the road, and the snow storage is right in this area here. I mean, and there's not going to be a snow plow in this area because it's all grass, but it would be a place for them to store.
Is the plan to throw those bollards up?
We felt that there was no need to put the bollards around the well because it's so far away.
If it's a condition of
We
approval.
can add them.
That's
Yeah, no
something
problem.
that we can do. The sixth comment was, because of the plan change, the snow storage is now adjacent to the parking area. And again, as Peter just pointed out, we've revised the location of the snow storage.
Where was it before?
Well, these two snow storages were down here where the pavement was. It was just a drafting error. It wasn't, the snow storage wasn't moved up to the paved area.
7, on the site layout plan, in the notes section, the number of units and the number of parking spaces must reflect what is shown on the plan, and I believe that has been revised also.
That has been revised.
Yeah.
Affordable units and handicap accessible units should be shown on a floor layout plan. The plan identifies affordable units should also be listed by number and bedrooms. It's our understanding that the location of the affordable units, okay, within the project is something that happens after construction, because we're not going to be differentiating between the units. All the units are going to be the same.
Interior as well?
Yeah, for the most part, yes. Yeah, they're going to be the same. And then, because it's sort of a moving target, we know how many affordables have to be, and then as you start filling them, sometimes somebody will move out from an affordable, okay, or from and they can change. So, but that's a process that after the project is completed, we work with the town for the assignment of exact locations of affordable units, and with the design of having them dispersed throughout the buildings.
Okay.
Because the water flow test was conducted at 214, the Water Department strongly suggested a new flow test measuring pressure and volume to assure adequacy be conducted, and the results submitted to the Water Department. I know that we tried to get a water test done. Was it ever completed? Okay. And again, that would be we would agree to a condition of the approval that be done. We attempted to get it done before the April 11th hearing, and I was informed that that didn't happen, and I apologize, but I don't know if it has happened in the previous 30 days. I would assume that it did, and I do not have the results for you.
It happened on the 21st.
Okay, and were the results provided to the town?
Yes.
Okay, because they didn't give them to me. Thank you. And those were the conditions or concerns raised by the town plan.
And Josh, what were those results?
The results were that the flow
Oh. Yeah, they are.
was 1325
GPM.
gallons per
Yeah.
minute, and the DPW recommends over 1200. So they were fine with that.
Okay. Questions from the board? Okay, seeing none, I think we'll open it up then. Public comment.
They're gonna come up here.
Yeah, they do need to come up. So as part of your settlement, what's the level of confidentiality? I mean, I realize financial stuff can't be discussed, but are they allowed to discuss any matter, any portion of the project?
I have committed to the abutters, okay, that I would not discuss any of the terms of the settlement that were not public. And the only thing that I know that was public was the part of it that it's a 120-unit, 4-story, 2 buildings. Okay, that's what we agreed to. If they want to disclose terms of the settlement, I have no problem with that. That's up to them.
Oh, the gag order is on you, not on them?
The gag order is mutual, but I would waive it if they want
Oh,
to
I
discuss
see.
the terms.
I
have no
see.
problem
I
with
see.
it.
Okay. I would. Oh.
Discussing the project.
That's what I want. It sounds like no. So, do you want to jump in?
I just want to make a quick point, and that is just to follow up on what Attorney Catanzaro said. So I would advise the board not to ask questions that could require the neighbors, the abutters, parties to the suit to divulge the specifics of their confidential settlement agreement. If they choose to make that information known, you've just heard a waiver from Attorney Catanzaro, but I wouldn't want the board to put residents, neighbors, abutters in the position of having to be responsive to the board, divulge details that they may choose not to because they've got provisions of an agreement that protect them from doing so.
Sure.
Just to be clear.
Sure. Go ahead, Mark.
Okay, thank you. Good evening. Knows that there is a full crowd here. Mark Tassoni,
There you
49 Hawthorne Road. I know the drill.
Yeah, you do.
And I won't have to ask the board if I have permission to speak, but you all know me in Asher, other than in other towns. Mr. Costello knows a little bit what I'm saying about that. The new plan, the revised plan, the front got pushed back. How much did it get pushed back to the back of the property? I'm asking the engineer.
No change.
So when you clear all the brush and stare off, that property line is still going to be there, and there's got to be no breaking of the buffer zones.
You want to restate, is that a question
Yes,
for him?
that's a
Can you
question.
restate that?
Restate that when all the brush is gone
From where?
from the property itself, inside the lot itself. It's got to go through soil testing and workable grounds and stuff like that. Because yes, I've been up there checking it out, like I check out everything else. That it's going to be wide open, but then again, it's got to be not a full square. How did you determine the diameter of what you got up there for your plan? That's my question.
The back, you talking about the back?
I'm talking about the full outline. How many feet is it to the lot itself? And how much space do you have?
It varies around the property. But like I said, the only change, everything else has stayed the same from the approved plan. The only change was up in the front along the street.
Okay. And it got, in a couple of nights, 46 to 50 for height, which is in that zone area is borderline to good. And the zoning board, and I'm going to try to be real careful in what I say here, is speakable to who? Does first selectman, or is selectman speakable to you in scenes, in projects like this? Who's going to talk to who back and forth? Because it involves the town, town's municipals and DPW. It's got to be a lot of working parts. Those are road traffic and clearance.
Okay, thank you, Mark.
Okay.
Anyone else?
Robin Hicks, 11 Franklin Road. I'd like the developer to show the rendering of the property, proposed, please.
The sort of like the 3D animated
Yes.
rendering.
Show the public.
Do you want to flip that one? I think it's on the back.
Back of this one?
And Robin, do you have a comment you want to make on this, or?
No, just asking for the, I know it was public.
Yeah, that rendering was prepared by artists, architects, and it was, the design of it was, and I know that it looks like it's in, somewhere in Indiana, it's not, was to try to show the area of change, as the board recalls, it was the setback area, okay, that building to the left was 50 feet closer to the front yard, and so that rendering was designed to show that there's going to be an additional green area between West Union Street and the building. We thought that maybe if we had some palm trees in there.
And
too,
it just
would
happened to catch it right at
it would
sunset
also
too,
look
I
good.
noticed, but,
It's really a depiction of the buildings and obviously not of the surrounding.
right.
Paul Kendall, 25 Olive. I'm a member of the school committee, but I'm here as a resident. First, I do want to thank you guys for all the time you put in. As the boards go around here, you're probably one of the most thankless boards. You're always dealing with gripes and those kinds of things. So I appreciate that. I've attended most of the meetings relative to this project. And throughout this process, the applicant has shown little respect or consideration for the town or its residents, particularly the neighbors of this development who will be most impacted. Instead, the clear intention is to use 40B in an attempt to strong-arm this board and the town into accepting a completely inappropriate project. The applicant has repeatedly attempted to mislead this board. A few examples would be, the applicant falsified the acquisition cost in the pro forma, claiming it cost 7 times that of the maximum value determined by Mass Housing. Then they claimed ignorance as to what the acquisition cost meant. The A2 units, of which there are 20 in the current plan, are listed as 1 bedroom, when in fact they are 2-bedroom units. The room listed as a den on the floor plan has an interior door, an exterior window, and a closet. By both code and the definition of any realtor, this is a bedroom. That means that 64 out of the 120 units, or 53%, not 37, are 2-bedroom units. The rendering provided by the applicant shows the buildings in this very nice rural setting, having no neighbors, no topology, no wetlands. Again, a clear intention to mislead or misrepresent the project to this board and our community. The applicant still has not addressed the environmental and safety issues related to snow management. On the west side of the project, the amount of snow storage is completely inadequate. There isn't even any snow storage on the north and east sides of the apartment building. The large snow area on the south side, south end of the west apartment building cannot be considered usable during a snow event. There's no access to it. And there certainly isn't sufficient snow storage in the other designated areas. 2 of the snow storage areas are directly along the apartment building and the clubhouse. The end of the apartment building is also surrounded by snow storage. Storing snow in these areas will adversely impact the effectiveness of both the egress of the occupants as well as the access for emergency equipment and personnel. The plan also shows snow storage areas that would block the access drive on the far west side of the property that was supposed to be accessible for emergency vehicles. On the east side, they have 3 snow storage areas located outside of a proposed fence. How's that going to work? They have pavement snow storage areas that are directly abut the 25-foot no disturb zone of the wetlands.
Do you mind, I'll put that question
Yep.
to him. Is there snow storage outside of a fenced area?
Do you know which area
Yeah.
you're?
So, on your plan, there's a fence here, and there's a fence here. And so you have this one, and this one are all on the other side of the fence, according to the plan. Whether you depict it on here or not, this code right here on the plan goes right along there.
Okay. No, it is shown that there is a fence and it has snow storage.
What's the answer to that?
The answer is a backhoe if that area is needed for snow storage. I mean, it's done all the time. And also, again, I really thought that this remand was the plan that was approved. I know Peter keeps referring to the bottom plan as being approved, but the plan that this board did approve, okay, would be in the footprint of what the proposed settlement would be, more or less, okay? And so these issues of snow storage, which we probably spent the better part of 4 meetings discussing, okay, are really not what is here on remand. But the answer to that question is yes, that if that area is necessary, we would lift the snow. You also recall that there's going to be snow removal from this site and possibly snow melting from the site.
And he brings, I mean.
No, that's fair.
Okay.
But you have to make a decision on what you're going to do here. So, and again, even what he just said, it's along parking spots. You still need a temporary place before you move. For example, the bottom side of that building on the left. You can't just simply plow snow over there, right? You'll need to store it somewhere first, push it somewhere first, and then use a backhoe to move it to that location. So you can't use that in the event during an event, right? So I mentioned that earlier. There's still the idea that the other 2 snow storage areas on the east side directly abut the wetland no disturb zone, and they're off pavement, which means that they are going to run directly into the wetlands. So they still have not addressed that. The applicant also submitted a snow storage plan that included non-parking areas for snow melting on each side of the project. That was when it was still a 4-building proposal. Those areas do not appear to be included on the current plans. Therefore, how would they execute their snow management plan that calls for snow melting? There's no areas for that. That were designated in the 4-building plan. I could continue to list the deficiencies that the applicant refuses to acknowledge or address, but simply put, this proposal is far too large for the site and will have significant negative impact on our neighbors in the town. For these reasons, as well as the overwhelming public sentiment expressed at these and other meetings related to this project, I urge the board to reject the proposal.
And you realize by saying reject the proposal, that's the mediated settlement that's in front of us right now.
That's the proposal I'm talking about.
Okay.
Thank you.
Thanks, Paul. Yeah.
Just a little bit about the mediation, if it was in fact a mediator, we went back and forth.
Yeah, we're gonna have to go in that discussion. Yeah. Yep.
Hi there, Jeannie Young, 46 Indian Spring Road. And I just wanted to say we're not against affordable housing, but affordable housing is supposed to fit the neighborhood. This absolutely does not. And I thought Angelo said that the Board of Selectmen should have nothing to do with your decision tonight, and absolutely they should be involved because we vote them in, and they should be helping the people in town and work with them on what's going on in town. So this is just crazy. It's not that we're against it, it just doesn't fit the neighborhood. And we hope that you reject it because we have nothing to lose anyways. If you say okay, then they're gonna get it. If you deny it and they get it anyways, at least we tried.
And were you one of the neighbors who was in part of the lawsuit, or?
Nope, I wasn't included in that, but I wish it was, because I guess there's a settlement or something, but, and if Angelo would like to send my kids to college with his grandkids, I'd be happy to have that, and maybe I'll get something out of this, okay? So you can take care of that.
All right. Settle down. All right. Additional?
Hi, my name's Kenneth Patad. I live at 124 West Union Street. I'm actually in a butter, and I didn't get a settlement either, so
Your kids can go to college.
Yeah, I know. I live directly across from this project. And just going from, looking at from 36 feet to 56 feet and looking at the picture that they already hid, that's a huge height difference from being so close to the road. Even 80 feet back, it's so close to the road to have 56. Driving down 135, it's enormous. That's just an enormous thing to see. And then you think about the parking, the snow removal. When you have so many spaces that they have to plow, all these cars, every time a snowstorm, they're gonna be moving out of there to get their places plowed. So you're gonna have a whole community trying to get out onto 135 at one time so the plow company can come in and plow the area. And now they have backhoes moving around. Nobody's gonna wanna have their cars in there. It's just gonna be a fiasco, just trying to plow every storm like 135 is anyways. It's a parking lot every morning. I don't know if we've done a traffic assess since the last time they did it on February vacation and on 4th of July weekend. I don't know if they've done another traffic report since then, but I live on 135, and at 7 o'clock in the morning, I can't get out of my driveway, as it is. I don't know how many people here drive down 135, but it's an hour commute to go from Hopkinton to Ashland Center. These are just a couple of my concerns, other than the wildlife, the coyotes that are approaching into people's backyards now. You can hear them crying every night, you know, so these animals need a place to go, and they're gonna end up in people's yards, attacking people's animals, their kids, and these are things that we have to think about when these projects are going on, so just thank you.
Good evening, I'm Sarah Moorhead. I live at 60 Franklin Road, and right now I'm pretty sure that I can confidently speak for the rest of my family of four. I was actually not aware of this whole situation until quite recently. A very good neighbor notified me of it, and I'm frankly horrified that this could even be proposed. Trying to get off of Franklin Road onto 135 at the mentioned 7 o'clock in the morning is next to impossible. I have had people go well out of their way to avoid even going near that section of roadway when dropping me off at home. The mention of the wildlife, I was frankly horrified to hear the idea casually put out of just mowing down all of those trees and then replanting them? How long is it going to take them to grow back to their original size? Yeah, palm trees. That's great. They'll do well in New England, right? Just the right atmosphere for it. I have lived in Ashland for my entire life, and I intend to stay here for the rest of my life, doing my best for the community and for the wildlife. Already, my Franklin Road that I live on is papered with squirrels. Kind of tired of it. We have a woodchuck that we actually have named on our property, and it was dead on our road this morning. I would not like to see a whole lot more of that. Prefer to see a whole lot less of that. And somehow the idea of putting a giant apartment complex right in there on a tiny little road that cannot handle it, seems like we're going to have a lot more squirrel guts just papering everything.
Good evening, Steve Mitchell, 5 Newcastle Road. I also serve on the Board of Selectmen, and since the board has been brought up in a couple of statements, I just wanted to confirm that the ZBA has received a joint communication from the Board of Selectmen and a personal communication from an individual selectman and resident as well. If you haven't, I'd be glad to read them into the record. If you have them.
We have them.
You have them?
Feel free to paraphrase.
Well, I won't
summarize.
Essentially, the communication from the Board of Selectmen, I'll just read the last paragraph there. The Board of Selectmen feels it prudent at this time to bring to the public's attention that we do not support the new compromise project remanded back to the Zoning Board of Appeals. The size and scale of the project is not appropriate for the neighborhood. The impact on service is detrimental, and it does not advance affordable housing in the town. The ZBA should know that it has the full support of the Board of Selectmen in rejecting this compromise, and we will partner with them should such a decision result in further legal and financial actions. So I'll leave it at that. Thank you.
Hi, Dale Buchanan, 7 Denise Drive, and I'm on the planning board, but I'm here as a personal, my personal. I just had a question. Do you have, because this is about the difference in 3 stories and 4 stories, right? The project's already approved. Do you have a rendering of the 3-story compared to the 4-story? And I would like to ask the board how adding another story onto this project helps the community and betters the community. Like, we had a couple of citizens come in that live here that had to go through the whole list of, is their little room upstairs gonna improve the quality and not deter, all that. So I would just like to know your comments on how adding another story to the project is going to help and enhance the community. That's it. And if they had a drawing of the difference between a rendering of 3 stories as opposed to 4.
I have not seen that rendering, and
But we don't have a rendering because there's never been a project that, I'm sorry, we don't have a 3-story rendering because we've never been in a position where we've had agreed to or agreed to build a 3-story project. The height of the 3-story project would be approximately 46 feet, which was the waiver that was granted by the board, and the height of the 4-story project is approximately 54 feet. So there is about a 10-foot difference in the project. I think what we're here tonight also is there's an incremental difference of 21 units between the 99 unit plan and the 120. So the concerns that the people are raising about traffic and all those other issues, which are very real, okay, and which were vetted during the public hearing process, you really have to focus in on is what difference is the 21 units going to make to this project? Is it that going to tilt it one way or the other? And again, and I agree with the members of the public, it's your decision, but we have to remember why we're here tonight, okay? And it was a process that we all went through in good faith.
And I suppose to address the question, comparing tonight, the earlier hearings where we went through a number of criteria, I mean, we had 2.5 years of putting them through that. So I don't want you to think, and I don't know if you came to any of those prior hearings, but they definitely got put through their paces for sure during those 2.5 years of hearings.
My point was just is adding the extra. It's going to benefit them. Is it going to benefit Ashland?
And that's what we're discussing right now. Yeah.
Kathy Rooney, 136 Fountain Street. Hi, Angelo. So I've got a couple of comments to start with. First of all, there were 4 agendas posted for this meeting. So when you go online to look, it's really unclear, is it the top one or the bottom one that's the latest agenda? And you guys need to do a better job making it clear to those of us who work for a living and come home and try to print out an agenda and then go, there's 4 of them. We spent a lot of money in this room on new AV equipment, and in the back of the room, most anywhere else in the room, unless you're standing here, you can't see those plans. And we all in this room need to be able to see those plans. You guys need to put that stuff up. You need to do it for every single project, for every single meeting. We need to stop being in the 19th century and move into the 21st here, please. Okay, so the scale of this project is incredible for our town. I have clients in Upton, and it's an hour to get there in the traffic. So this isn't going to help that. It's going to make it worse. The traffic in our town is insane. The snow removal stuff that other people have already been talking about, that's just going to add to the craziness. I'm very curious, because I'm on the Water Policy Committee, how much of this is planted in lawn versus how much of it is planted in xeriscaping, trees, shrubs, eco-grass, things like that. And I'm kind of curious why they need an irrigation well at all when we're trying to get people not to use water in our town unless we absolutely have to. Now, I understand from another neighbor of the property tonight that there's some huge, beautiful trees on that property, and those are one of the best things for creating a landscape that looks like it's already been there. So I'm wondering if the plans are accommodating those big trees, and if the developer's going to try to save them and work around them and keep them in place so it makes a better looking building, series of buildings for everybody. The infrastructure costs to our town for this project are going to be enormous, and I know that we don't think about that enough when we do projects in this town. So we're going to pay for this down the road. We're mortgaging the future of this town with developments like this. Rail transit, all of them. We need to stop. And how many of these units are actually affordable? And are they permanently affordable?
They are permanently affordable. Was it 25%? So depending on which, the 99 or the 132, you can do the math on it. It's roughly 25 to 30, I guess.
Well, I'd be a lot happier about this if it was all affordable, because I would knock our percentage up and would be less, would be more able to
Because they're
hold off.
rentals, the strange thing is we get to count all of them towards our affordable housing stock.
Okay, but they need to be affordable. I know what they're charging over at the Rail Transit District, and it's not affordable. Thank you.
Sure. Okay. Discussion. So the three voting members, myself, John, and Stu. A lot to go over, but so let's, I guess, a little more discussion on the mediation that happened. And do you want to?
I'd like to.
Okay.
Is that possible?
Yeah, that's fine.
All right. Renee Thompson, 6 Crestwood. Resident here for 10 years. 2 little girls in the school system. Youngest one is at the Warren. Last year, she had to attend class in the modulars due to there being an influx of children coming into the school, which is great. But now we're going to add another potential 120 units into the town. And so I asked how many kids would that bring. I was told the number was 10. Seemed kind of silly, but the banter went on, and I asked and said, how did you come up with that number? And I was told it was a state formula. Again, seems kind of out there that 120 units would only bring 10 children into the school. The school is already planning on getting an extra 2 more modulars to add to the Warren School, which is apparently got about 600 kids in it. We don't have room to build another school in town. What's going to happen if 60 kids come in? What happens if 100 kids come in? Now, granted, they all won't be in the elementary school. They'll be spread out, but the Mendez is falling down. There's no room there. Warren is overcrowded. There's no room there. This is a resource that we have that I don't know if has been vetted. It probably has, but it's now becoming very real that we could have more kids in town than we can actually sustain. So that's my point.
Thank you.
Hi, Judy Margulies, America Boulevard. I'm also a member of the Board of Health, but I'm not speaking on behalf of the Board of Health. But I would like clarification, as I understand that there's an irrigation well here and possibly some other health-related items. Could you inform me when those items came before the Board of Health?
Angelo?
I don't know whether or not they have come before the Board of Health. My understanding is that this project is serviced by municipal water and municipal. I believe, I'm not sure.
Irrigation wells.
Oh, irrigation wells. I don't know whether it has come before the Board of Health. I don't know. And I don't know if it's necessary to go before the Board of Health. And certainly we wouldn't get a building permit if it was required to go before the Board of Health. So.
I will ask town council, just because I know the 40B statute trumps a number of that and puts it all in our lap, but is that something that would fall within our purview as well?
Well, not if waivers haven't been requested from otherwise applicable requirements. I don't recall any having been requested.
Okay. So if one, so at that point, they would need to comply with Board of Health if it wasn't requested. Okay.
That's correct.
Thank you. Cammie Townsend, Warren Road, speaking on behalf of myself and my neighbor. Thanks, Karen, for dragging me here. Really have to say that I am frankly appalled at how, attorney, and I'm sorry I did not even catch your first name, your attitude towards the town and veiled threats about how you could continue to litigate proposed mediated settlement really kind of very much rankled the residents of the town. It really, for a town where we're trying to talk about affordable housing, to then turn and say that you could litigate it and you could afford to send your grandchildren to school on our backs is very inappropriate, and you may wish to consider reframing your attitude when you're talking to the members of this town, because it would probably go a long way towards making this project more welcomed. You know, and I have to say, the concerns that as parents we have about this school system are real. I've been a resident of Ashland since 1999. I bought a family house with 4 bedrooms without children because that's what I knew I was going to be having, was children to move into what was a good educational system. And it is. I'm so far very pleased with the education my freshman and my new 4th grader have had. But, you know, they're walking into a high school where there's still brand new, there's buckets to catch leaks in the ceiling. You know, hopefully that won't happen in the new development. I would hope it doesn't to your roof, because I certainly know what ice dams are about in my lovely single-family Ashland home, as I'm sure many of you also have had that lovely experience. But, you know, I'm sorry, you're by your own Facebook website, you're only going to be generating $230,000 a year in tax revenue for this town. I'm sorry, but the costs alone, emergency services, hookup for and cost in water. I mean, how much is it going to cost us to hook up to MWRA services? How much additional cost are we having for managements of road, DPW, et cetera? It certainly isn't going to be offset by $230,000 a year generated by this particular project. Yes, I understand the Zoning Board of Appeal tonight is really talking about ratifying the proposed settlement or the remand. However, you know, what you're hearing from the residents is that we don't want you to go ahead and accept it. Yes, we understand you spent all day negotiating a settlement. That, yes, 21 units is incremental, but it's only 20 units short of the original proposed 140. 99 is still a large development in sight. You know, one of the questions I would have for the zoning board is to actually look at how many affordable housing units do we actually have in Ashland? How many have we added with the Cirrus apartments? Don't all of those count as affordable housing units? How many have been added with the new assisted living residences on near the Shaw's Market? How many have been added with, I made a list here. Of course, I took my glasses on because I'm also getting older since I moved here. The Lanterns residencies, which are the 55-plus community. You know, is 3.9%, as has been promulgated by Capital Group, really the figure that we have for affordable housing? What about the Chestnut Hill apartments, the Oak Tree apartments?
Yeah, it's a good question. I think we're still under 5% actually, and
right now Ashland is, I think, as of a couple of months ago, it was 3.65, I think. Since then, we have applied for all the ones at Ashland Woods, a couple developments at the Village of Americas.
Yeah.
There are a few others as well. I think we are now up to, I think, over 5%.
It's actually, counting this or not counting this? I think that number was including this.
Counting this, yes.
Yeah, that's.
Does that include the Cirrus apartments?
So we're still well below, unfortunately, 10%.
Right. Which, again, knowing the makeup of the town, knowing that we have colleagues and friends in Ashland who tell us they can't find affordable housing, that have been unable to sustain housing costs for single-family dwellings, but can't find housing for them and their children in Ashland. I don't see how this is going to be helpful. We have an awful lot of housing for assisted living type residents, 55+ residences, which, yes, does generate some income for the town. It doesn't solve our issues with the schools, modular schools, Mindes School. I love Mindes, but it is not meeting the needs of the contemporary student. And we're not going to have our students continue to have our school systems at the level they need to be in getting our students up in STEM and at the level they need to be in order for our students to be successful and come back to this town. This development also is not going to provide a significant source of jobs. The construction jobs aren't going to employ local construction. They're going to be pulling in construction from all over. So again, we're recommending that the Board of Appeals does not support the settlement.
Yeah.
Thank you.
Yeah. So, show of hands, any other comments? I just want to sort of budget the rest of the evening. Okay.
Hi, Joanne Scotland, 142 West Union. I live directly across the street from this property. And I just want to bring it back to the 4-story that we're talking about. And remember that this is a residential area. And we're talking about a piece of property that was a farm. And now we're talking about several 4-story buildings in a residential area where we have a state park and a community center. We actually are a very nice end of town. And now to have this is it's ludicrous. 4 stories is just crazy. That's all I've got to say. Thank you.
I appreciate that, and it's a good segue into our discussion on this because, so really that's what's in front of us, right? The 99 units at 3 stories that we had approved, I forget the date that when we approved it now, or this, and I'll call it a mediate settlement, but I want to talk a little bit about that as well, at 120 units. So a couple of things, and let's start with the Board of Selectmen. I appreciate their input. They do appoint us, but we take everyone's input, so that's just part of the equation, and we appreciate it. But we're definitely going to make our own decision as we're expected to. I think Angela mentioned that something about the project we wanted. We didn't want any of these projects, Angela. This is 40B. Project we approved. Correct. And then a little bit on the posture of the mediation, because when we went into that mediation, it was mandated, and yeah, you got to go in with an open mind. But if it hadn't been mandated, I don't think any of us would have agreed to mediate. We spent 2.5 years. We came to that decision, and we thought it was a good decision. Good decision. We thought it was the best decision we could render under the statute. And a lot of that was driven by what we believe the economic test to be. So that's how we went into mediation. At that point, it was the 4 of us, I think, that were there for the first part. And one of the first pieces of information we were handed was that, the test that you thought that you used to determine whether the 99 units rendered the project uneconomic, that test is an old test, and the new one renders the 99 units renders the project uneconomic, essentially saying you're going to lose at the HAC. The first we heard of that was when we sat down in mediation. It sort of put us on our back heel because I'm not going to speak for the rest of the board, but I was going in there because I had to, and I had no real intention of of negotiating because I was happy with the decision we had rendered. And then, John and I had to leave, and the rest of the board, and I'm sure, sat through it and did it in good faith, and I'll let you guys speak to that. But I wasn't part of that final decision, and I semi-resent, Angela, the implication that I'm bound by it. I'm not, I'm not, and I'm going to vote the way I want to tonight. So I probably have more to add, but I'll hand it over to you guys.
Perhaps for the public who's never participated in a mediation, there was an attorney of many years' experience in land use planning who served as the mediator, and Phil and I, there was an open gathering. Phil and I were at it. Our town council was there. Representatives from the applicant, the developer, were there, and representatives, two of the abutters and their attorney were present, and basically went around the table and said their respective positions. At that point, the parties broke into separate rooms down in the basement here, and Phil and I met with the others, and then we had to leave because of other commitments. And my understanding is that the mediator, this very experienced attorney, went back and forth between the parties to sort of establish respective positions and try and facilitate an agreement if there could be an agreement. And I guess I'd ask town council just to confirm that. Is my understanding that's what worked, and back and forth, back and forth, back and forth until there was a potential resolution. I would agree with Phil that the first I heard that perhaps the standard that was, or test that was used by our expert was one that was no longer being used before the HAC was at that meeting, and it took me greatly by surprise, and none of us were very happy about finding out that information. And that's all I'll say about the mediation.
And I'd like, because you guys sat through it, to hear from you, but my impression leaving that there was, our position now was completely changed, negotiating stance, and was being driven by this belief that, the test that we had used wasn't effective anymore. And so we had to negotiate, but I don't want to put words into your guys' mouths.
That's what happened. The experienced attorney told us we don't have to accept it, but if we don't, it goes to the housing court, and our chances there are slim. We were told that the test wasn't what we thought it would be on the finances, and we were pretty much it was kind of forced on us that we either accept this or it goes to the court. It's pretty much what it came down to.
Stu?
I also echo what Brian summarized. There was no real explanation as to why the 99 unit proposal was not acceptable, other than the fact that the economic test was not current. And it was a total surprise.
You want to throw anything in there, or are you good?
If you'd like me to.
Only if you want to, Adam.
Well, I want to add a few things just for clarity of the record, and so there's no misconception as to what occurred. And I think the members of the public who participated tonight were very respectful with respect to their comments about the project, and specifically about the board's work on the project. The board, as is any board reviewing a 40B project, but certainly one that has been challenged by a developer, is in a difficult position. And I'm not going to discuss the relative strengths or weaknesses of your argument in defending the decision that you rendered, because depending upon the outcome of these proceedings, I may be in a position where I'm defending that same decision. So I'm not going to talk to the strengths or weaknesses and the detailed discussions that were had in mediation were had in executive session, so I have no intention of getting into those. But insofar as there was a discussion about the economics of the project, I mentioned before in my introductory remarks that it's essentially a two-part inquiry at the Housing Appeals Committee, and will continue to be a two-part inquiry if this case proceeds beyond the Housing Appeals Committee to the courts. And that's the case for any approval of a comprehensive permit with conditions. The first step in that inquiry is an economic test, and the question becomes, by imposing the conditions that you imposed or refusing in part the waivers that you refused, are you rendering the project uneconomic? If you are rendering it uneconomic, then you proceed to the second part of the test, and that second part asks, do you have local needs, and local needs are very narrowly defined by the HAC and DHCD, do you have local needs that trump or supersede the presumptive need for affordable housing in Massachusetts? The information you received from your own consultants during the hearing process speaks to the second part of that test, whether you had justification for a denial of the project or conditioning of the project based upon local needs. And I'm not going to touch upon those again because I may need to defend those. But the board relied heavily upon the economic test in imposing the conditions that it imposed. And that economic test was not just something that it based on the information submitted to it by the applicant, but you based that economic test also and its application on what you received from your own peer review consultant. And something was said in a few of the remarks that were made, and I want to clarify, and I certainly know that you were aware of it during the mediation because we discussed it at length for the better part of a day. And that is that it wasn't that the wrong test was used. We engaged a consultant with decades of experience reviewing 40B projects and applying these Housing Appeals Committee tests. And there are 3 different tests that are used by the committee. It was simply that in the interim, between the date of the pro forma that was submitted during the review process to this board and the date of our mediation, the variables that are utilized in the formula, at least according to what was submitted to you by the applicant, had changed. And so that was some of the sum and substance of what the board was working with when it considered this project in mediation and considered a potential change to the project is, all right, we were told during the public hearing process that this particular project would be economic at 99 units, and that by approving it at 99 units, we wouldn't be worried about that first part of the test. And you heard something different, at least from the applicant's consultant, and you had your consultant present to vet that at the mediation. Your consultant, our consultant, was present for the full term of that mediation all day. But that was really what was at issue, is have those numbers indeed changed? And if they have changed, how does that change your position as a board in your ability to potentially support a conditioning of the project in the manner that you conditioned it back in October of 2016? So I just offer those points of clarity in terms of what the board was faced with. Again, you have an unenviable task in having to weigh that test and what lies ahead in terms of litigation against the proposal before you. But I think that's something I want to add just so the record is clear as to what the board considered and why it considered it. And I don't think some have mentioned or expressed sympathy for the board spending the better part of a day in a mediation. I got no sense, and you can speak for yourselves, that anybody was okaying a potential mediation or potential mediated solution because they were just wanting to get out of the room after 6 or 7 hours. I think that we just worked through this, and as was described, Attorney Krieger, who was the mediator, went back and forth to the respective parties on multiple occasions throughout the course of that day and trying to broker a resolution that resulted in improvements to the project. Whether those are sufficient, I leave that to the board.
Thank you. So here we are. I don't want to influence the group too much as chair, so to the other 2 voting members, where are you guys at?
I'll volunteer to go first, I guess, before I'm drafted. I have thought from the beginning that this proposal is too large for the location. However, as we all know, Chapter 40B is different and allows a developer to seek waivers of the various zoning bylaws that a municipality has in order to build the project that it seeks to build. As the Zoning Board of Appeals in Ashland, I view our role as being the arbiter of the Ashland zoning bylaws. People come before us for special permits like you saw earlier this evening. We determine what our bylaws say and whether or not the application meets those bylaws. Chapter 40B, however, is different. By definition, it doesn't meet the zoning bylaws of the municipality, and that's why they come before us to seek general waivers or modifications in a number of different applications. We spent 2.5 years on this project with hearings. I was present during every single one of those meetings, and we heard the evidence. We considered what we were faced with, the cards we were dealt with, and we made a decision that I think was the best decision that could be made and that could be supported under the circumstances, and that's the decision that we rendered in October with a 3-story height limitation and 99 units. I wasn't 100% happy about that, but I thought it was the very best that we could do based upon the evidence that we had before us. The proposed compromise of 120 units, but with 4 stories, is difficult to consider. I think one of the things that, and I shouldn't speak for everybody, for Phil or for Stu, but that I have in the back of my mind is that if we were to stay with the original decision and the developer appeals it and ultimately prevails, then the project that would go forward most likely is not going to be 120, but it's going to be 132 units. And rather than have the further setback from the road, it's going to have the lesser setback that the plan showed. So in a sense, do we take a gamble and go, say, basically 12 units, but get more frontage and perhaps better landscaping to shade it from the public? Or do we run the risk, stick with our original decision and take our chances before the HAC or any court that the HA decision might be appealed to? If we were to do that, the expense to the town is not insignificant. There will be attorney's fees and other costs incurred that will be paid by the town. As a member of the Zoning Board of Appeals, I am reluctant to commit the town to that type of expenditure because I don't think it's my role as a member of the Zoning Board of Appeals to do that. However, the Board of Selectmen, in the statement that has been submitted to us, indicates that they are willing to join with the board and to incur those expenses to support our original decision. I think that decision is a political decision that needs to be made by the Board of Selectmen, who are the elected representatives of all of the citizens of Ashland. And I, for one, if they're prepared to do it, then I'm prepared to allow them to do that if it becomes necessary. I think our original decision was correct under the circumstances. It allows for affordable housing to be built within the town of Ashland, and the project, whether it's 99 units or 120 units, is still too big for this site, but I think it's one that we felt was supported, and if the Board of Selectmen and the town is willing to take its chances, then I'm fine with that, because I think the original decision was proper under the circumstances.
Thank you. Stu?
To be very brief, I also echo the summary that John has presented, and I would be willing to support the 99 units, but not the 120.
I mean, that's where I'm at as well, but I think the only thing I'd like to add is, I mean, the only reason here at all, in my mind, is because when we walked into mediation, we were told that our calculation had been wrong, and you did a great job of explaining it. But in our minds, now the project was at 99 units was going to be rendered uneconomic. But I've had some time, and I've been in real estate as an attorney for 20 years, and yeah, we'll probably lose at the HAC. That's, and I don't want to box out of it, but that's probably the reality. We'll probably lose at the HAC. I'm more interested in the next, in the appeal to that, because I don't think that the economic test reflects reality. It reflects market reality. And as Exhibit A, if I was arguing this case, is that we were told that the 99 units makes the project more uneconomic than I think even the 132 unit under this new economic test was uneconomic, which they were willing to do, and they're willing to build 120 units, which under this test is uneconomic. Well, there's no builder I know willing to do a project that's not economic. So I think the legal system, the judicial system, really needs to take a look at whether that test reflects market reality, and that's the case I think that we have in front of us, and I'm proud to send that up into the judicial system. So, having said that, I also am opposed to the mediated settlement, and unless there's further comment, I'd like to vote on it.
Said my piece.
Okay. So for the three of us, Adam, we need a roll on this, or just?
No roll call necessary.
All right, so I will entertain a motion to reject the mediated settlement and to affirm our original decision.
I move that we reject the mediated settlement and affirm our decision of October 2016.
I second that.
All in favor?
Aye.
Aye. Opposed? Abstain? That is it. All right. Thank you, everyone, for coming out.
Nice, man. Tough. Yeah.
That was a tough one.
It was.
Well said, though, John.
Yeah, as always. Yeah, good job, man.
Fortunately, I stayed focused. My mind didn't start to wander too much,
No,
But I always worry about that when I get going. Sometimes I start to zig and zag.
Is there more?
Brings me back to, I'm like the old fire horse that got retired out of the pasture, but then he hears the bell and he starts to charge it in, Brought me back to days arguing before jury.
There was a lot of emotion, compassion.
But this is difficult for everybody. Even the developers, money, but they've expended a ton of time and money on this, and they're going to do more.
Do you guys want to take a 2-minute recess?
Like 2 or 5 or something, just to stand up.
Is someone from WACA still here? We're going to do... you're the man. right, welcome back, everyone. We are at our last agenda item, hearing number 4 for this evening. The Joseph E. Connolly Trust and Michael J. Connolly and Sons, Inc., parties under agreement to purchase the properties, have applied for a special permit under Chapter 282, Section 3.12 and 9.3 of the Ashland bylaws to allow commercial parking facility for parking of school buses and bus drivers' automobiles when buses are being operated. The properties are located at 11, 13, and 75 Chestnut Street and 10, 12, and 13 Brook Street in the Highway, Commerce, and Industrial Zoning districts. A public hearing will be held on May 9th, 2017 at 8 p.m., which we're a little past that now, in the Board of Selectmen's room located at Ashland Town Hall, 101 Main Street, Ashland, Mass. Parties wishing to be heard on the matter should appear at the time and place indicated above. Okay. You're on again, Mr. Efron.
I have a lot of respect for you people, more than usual. Somebody should think of thanking you for doing this job once in a while.
Buttering us up's not going to help. Go ahead.
And it's not going to be me.
No.
For the record, Jerry Efron for the applicant. We are here seeking a use permit only. That is all that is before you. It's for a commercial parking facility under Chapter 282, Section 3, the Table of Principal Uses. Because there are no separate criteria for that, we have to satisfy, as far as standards, 9.3, the general special permit criteria. Both myself and my submission and Attorney Zaretti, who has filed paperwork on behalf of the applicants, are in agreement that those are the standards and criteria that must be met by the applicant in this case. Here with me tonight is Bert Corey of Schofield Engineering, who'll go over the plan.
Welcome.
You'll note that the plan is was authored by Joe Sullivan of Sullivan Survey. I'm sad to report that Joe is gravely ill to the point where he had to literally sell his practice last week.
Oh, jeez.
Schofield bought the practice, and on incredibly short notice, Bert was able to get up to speed on here, and will be able to provide the engineering support that we need tonight. And I wish Joe Sullivan well. He's been a great engineer in this area for 30-plus years, and he's just not going to be able to work anymore. Also with me tonight is Steve Sullivan, the CEO, Steve Conley, the operations manager, and the owner of the company in the second row, Joe Conley, and his daughter-in-law, Anne Marie Conley. Currently, the Conley Bus Company has been providing services at this site for over 20 years. The submissions all support that, and even the submissions by some of the abutters indicate 20 to 25 years. So we've been there for quite a long time. We've been utilizing what is known as Lot 3 on the site plan for both bus and car parking. Currently, we have a contract with the town. That contract with the town, among its requirements, are that the buses be primarily housed in the town of Ashland. They must be parked and sited here. It is not legal for them to do otherwise. If they do otherwise, they will be in breach of that contract provision. They hold buses for Ashland school children, for Ashland school children that use Keefe Tech. They also hold Hopkinton's buses.
Just quick, why is that provision not in the Hopkinton contract?
I do have no idea.
Okay, so that's
It
just
is not,
something
it is
unique to
not a
Ashland.
state law requirement.
Okay.
That has been a local requirement for as long as Ashland has used the school bus company. Ed Nowles, the previous provider, also was housed here and was under the same requirement. They were the predecessor to them, and that contract provision, as far as I know, has been in existence for well over 20 years. It is a local requirement.
Okay.
One of the benefits of that local requirement, in addition to obviously having the buses more proximate to the schools, so that you theoretically have an easier time making the drives at the appointed times, is that the company has to pay excise taxes where the buses are parked. Currently, the town pays $69,000 approximately in excise taxes to the town of Ashland. They currently are under lease for Lot 3, which they've been under for quite some period of time, both from the prior owner and from the current owner, W.D. Homer. That's a parcel of over 80,000 square feet. They currently park school buses on that site, and also to park the drivers on that site where they're driving the buses. There's currently room for all, but there's quite a bit of jockeying that has to go on. By that I mean that when the buses come in, they first have to have the drivers come in with their cars. They park their cars. The buses are already parked there from the night before. the buses have to move out, and it's kind of like it's almost like a valet parking situation at a crowded venue. It takes a lot of work to get in and out of there safely. To the credit of the company, they've been able to do that. They've been able to utilize the existing access on Brook Street for that purpose to then go on their routes, and the drivers do the same thing. They are now under agreement to purchase that land, as well as the lot that is right up next to it, which is known as Lot 2 on the plan. That is a lot of over 30,000 square feet. This agreement was signed back in October 16. They were scheduled to close in April 2017. The historical use of this property is relevant for a number of reasons. The section of the use table labeled commercial parking facility was added to your zoning bylaw in 2009 as part of the recodification of the entire bylaw. I inquired of staff to try to find any particularized minutes for the planning board to see what the intent was of this bylaw. There were none. The reason there were is this is simply part of that codification. It was not something that was separately proposed as an independent bylaw change. So we have to simply utilize the clear words to try to figure out what those were.
Was there a predecessor provision?
No, that was a new requirement. There was nothing before. That bylaw use table did not replace anything else. There was no such thing as a commercial parking facility use. We were provided with a copy of your 2016 decision on Pond Street. I was familiar with that because I know the people involved, and I reread it. That was clearly a commercial parking facility. That was a conversion of property that was used to store mulch and fertilizer into a facility that rented for profit commercial vehicles, RVs, and things of that nature. As a result of that, there was a full application of the zoning bylaw, and as a result of that, there was also the mandating for site plan review because it was a complete change of use. Both of those decisions were rendered, conditions were imposed, and that permit did issue. Frankly, we have a question as to whether we're even in the right place. Part of the position that can be taken here by the applicant, which may not be advantageous to the neighborhood, is that, frankly, they are completely and totally grandfathered, that they are not, in fact, a commercial parking facility. All they park there are school buses with school bus plates, not commercial buses. They do not, have not, and will not rent out the property for hire for any kind of commercial use whatsoever. I don't necessarily need to go further with that because we're here consensually.
Exactly.
We're here consensually because, as everyone on this board knows, and as you really just had an unbelievable opportunity to witness, it's the advantage to every developer and every product proponent to get their zoning rights in a permit, to make it clear, to make their rights clear, and to make their obligations clear. In a perfect world, that's what everyone wants. It's the way to enhance the value and have predictable use of your property. That's why we're here. A check of town records and confirmation from the building department indicates that there have never been any structures located on Lot 2 and 3. No permits have ever been applied for seeking to have any such structure. Both of these lots have been used for parking for over 50 years. These are pictures, I'm sorry, short arms. These are pictures from 1966.
Are these all identical?
Identical, I can pass them, thank you. They show, and I have circled in red, the two lots in question. You'll notice that there are cars parked in both lots. That's 51 years ago. I have absolutely no evidence that would indicate that cars were not parked there or that these lots were used for anything other than parking. The configuration of those lots is particularly important. On the easel, the engineer has indicated today's picture. The parking lots are pretty clear. One has the yellow in it for buses, and the one right to the top of it, top left, as you're looking from the board, and if you can see from the audience, is the car lot. You can literally compare the configurations that are the same. So even though these A&R lots were just A&R'd, the assessor lots and lot boundaries and configurations have been in existence for over 50 years. In 2001, this is a picture from 2001, okay, showing the same lot, clearly showing that at that particular time, Lot 3 had bus parking in it, and Lot 2 had a massive amount of cars in it. All right, why is that relevant? Well, it's relevant because that shows the accurate state of facts of things prior to the zoning bylaw change in 2009. And again, in the materials provided by the attorney for the abutters, there's plenty of statements in there indicating that this has been going on for 25 years. Before filing with the ZBA, and after determining to go in this particular direction, the company met voluntarily with the neighbors. It was a meeting where we excluded public officials. We had nobody there from the town. It was just the company and the neighbors. The purpose of that was to have a free exchange of ideas without people worrying who might overhear them, so that we could try to mitigate neighbors' concerns and address them. As a result of that meeting, we made revisions to the plans, arrived at a set of conditions to try to get closer to alleviate and mitigate some of their concerns. Only after allowing that input did we go ahead and file the plans. Sadly, tonight, we're not in complete concurrence. Having said that, we're not 180 miles apart either, at least in my judgment. The company made several revisions to the plan in response to the neighbor's request, notably providing for 2 new proposed curb cuts onto Chestnut Street. The desire of the neighbors had been communicated in that way through us even prior to meeting with them by the town planner. I had some preliminary concern that both of those might require alterations under the Rivers Act. Those concerns were at least informally alleviated by staff. Unfortunately, that proved problematic, and upon verification by our new engineer as recently as yesterday with a tape survey, both of those curb cuts, if we wanted to put them in, will require permits from both the planning board on the floodplain and the Concom under the Rivers permit. Accordingly, we are not seeking to utilize those access points now, and in the conditions that I have filed today, I'm indicating that we will not use those unless and until we seek all applicable town approvals. So we're left with having to utilize what we have as existing, which is the access from both lots onto Brook Street. The changes, however, that we've made are many, and those changes we believe will significantly mitigate this use. Seller's property includes this lot in question, and it also includes other properties. These properties have been utilized only for parking and nothing else. The only thing that happened besides the parking use, regrettably, is something that has raised the ire of a lot of the neighbors and frankly was significant justification. The town's contractor doing the public works project for the town used Lot 2 and staged in that area for a period of 6 months. To put it mildly, they abused, in my judgment, the rights of the neighbors. I first took a look at that myself shortly after being retained in late February, and I was appalled. I was appalled because the way that lot was being run, there were stockpiles of material, equipment all over the place, garbage, refuse, and junk, and the stockpiles were causing a problem. They caused a problem with flooding in the direct abutter, Mrs. Kelly, who was right behind the property. The reason I know that's what caused it is in the pictures that were supplied in the petition from the attorney. The picture clearly shows the construction equipment, not the school bus equipment. That picture was taken while they were staging in that area. And obviously, they changed the contours of the property temporarily by their stockpiling materials, and then water, instead of flowing down the natural contours towards Chestnut Street, flowed in the wrong direction. That's not going to happen here. In fact, with the seller's cooperation, we have a tri-party agreement signed with M.E. Smith that binds them on or before May 31 to resurface that area, to regrade it so it restores the natural contour that slopes away from the property. That will be supervised by both the representative of the seller and Michael Conley to make sure that the elevations are what they should be, and so that we should not have the kind of problems that were experienced, which really had nothing to do with Michael Conley. In taking a look as to what the impacts are here, I want the board to also look at what the impacts could be. This property is zoned in the Highway Commerce District. That district allows, as of right, a lot of uses. In my opinion, those uses are more impactful than the use here, which is a parking use, which although every use is impactful, I suggest that this use is less impactful than some of the uses as of right. For example, a construction yard or landscaping business like M.E. Smith is a permitted use as of right in this district without special permit. A child care facility, a motel or hotel, a retail establishment or group of stores in a single building, a restaurant including a fast food restaurant with a drive-through, banks and banks with drive-throughs, and with special permits, motor vehicle sales, motor vehicle repairs. I'm not suggesting that some of those uses wouldn't require approval processes, but the point of the matter is the property is available to be utilized for uses that would potentially be significantly more impactful than this use. This use is significantly impactful in terms of the times when the buses and the cars enter and leave. Beyond that, there is no use. In the summer, there is no use. Once school ends until school begins, this property is basically mothballed except for the parking of the buses. Before my engineer comes up to basically talk about the plan itself, I just want to go through the special permit criteria and why I suggest they are met in this particular case. One second. We submit that the board should grant the special permit because we can satisfy the main standard of Section 9.3, that the adverse effects of the proposed use will not outweigh its beneficial impacts to the town in view of the particular characteristics of the site and the proposal in relation to the site. It calls for continuation of the historical use of the property, not a change of use, and it's in particular for school bus parking and the associated use of their drivers. Currently, the applicant uses the property for that purpose. There will be no change of use. It would be very difficult to argue that the effects of the proposed use for which we're seeking the permit will be more detrimental or will be adverse in any way, shape, or form. Although the proposed use does generate impacts, they're less intensive and intrusive than those that would be created by other permitted commercial uses of the property. And the uses are temporal. They're temporal not only by season, but during each day. Although it is correct that because they use buses for different schools and at different times, it's not just 5 minutes in the morning or 5 minutes in the afternoon. It's not a 24/7, 9 to 5, or a use that could be more impactful. There are community needs served by the proposal. It'll serve the substantial need because it will, A, ensure that the continuation of the service will be provided by Michael Connolly and Sons. It's been a valued partner of the town for over 20 years. It'll comply with the provisions of the school bus contract, as I indicated before. Traffic flow is going to be increased by this particular proposal in a number of ways. Number one, instead of cramming all of the cars and buses into one lot, we're going to be spreading them out into two. We're only going to be adding 9 buses in the second lot, and those buses are going to be proposed to be parked away from the neighborhood, but more towards Chestnut Street. The residential parking that will now be in that lot will be less intensive and certainly less inclusive than it was as its maximum, and less intensive and less inclusive as it is now. Right now, the people that park in that car use the businesses and structures across the street. They will not have that use anymore, again, as I indicated. If in fact this closing goes through and they acquire the property, they will have exclusive use of this property. It will not be shared with anyone else. There will be mitigations in the form of conditions that will no longer allow even cars to turn, quote, up Brook Street. So buses didn't turn up there now. Now cars will not be able to turn up. We propose conditions to indicate that will not happen, and we've adopted protocols which are attached to those conditions that will make sure that the drivers adhere to those conditions and will be punished with mandatory discipline, including progressive discipline and even loss of job should they violate those conditions. We will not be driving any cars through the residential neighborhood.
Jerry, can I just, on
Sure.
the last point, so who parks in that second lot right now?
People that are utilizing the businesses across
office
the street.
buildings?
Yes.
And so the plan is for Connolly to use both lots entirely? They're not going to sublet
Yes.
any of it?
Correct.
Okay.
Yeah, that should be a condition.
You know, it will be.
frankly.
Yeah.
And if I didn't put that in precisely, it's an oversight. But yes,
okay.
the intent is that they will have the exclusive use and will not be able to sublet or share that use with anyone for any purpose whatsoever. The total amount of buses and cars and spaces will actually decrease from the amount of spaces that are there now, even though we don't control what's there on Lot True. When you add the total amount of spaces, the total impact and total traffic, we will have less total vehicles being utilizing and parking there. To augment the directional situations and restrictions, we will be installing signage that will direct the traffic in the manners that it should go. With respect to adequacy of utilities and public services, use of the property for continued school bus parking will not require the construction of any buildings for human occupation. There will be no need for hookup to the municipal water and sewer system. No new stresses will be imposed on those systems, which, as we all know, are already seriously overburdened. Lighting will be provided by pole lighting as shown on the site plan, shining onto the property with no off-site spillage. A sanitary porta potty to be serviced by a contract with a vendor will be located as shown on the site plan on Lot 2. We do not object. That plan, as the engineer will tell you, shows that the porta potty is 68 feet from the closest residence lot in the back. If it needs to be moved forward, we can do it, and we will do it. As far as the neighborhood character and social structure, the property already abuts a developed commercial property on Chestnut Street and residential property on Brook Street, but it's been that way for at least 20 years. We've attempted to do our best to alleviate and address the neighbors' concerns. No one is going to be completely successful in those attempts, but we've given it a very significant effort. Because there'll be no subsurface excavation on the property, other than the minimal intrusions incidental to the construction of curb cuts, if and when they're approved, the use will not change any existing drainage patterns or cause new impacts. Without that, there'll be absolutely nothing. We're simply going to be patching and repaving too. We're not going below the ground, and that's important because this is an environmentally sensitive area near Cold Spring Brook. There'll be no discharge of hazardous substances into the environment caused by the proposed use. The applicant will continue its method that it is utilized of weekly fueling the buses via a portable fuel truck operated by its employee, a retired ex-Marine, with equipment requiring by-hand fueling. No employee not to leave unattended, and the fuel truck is equipped with spill mitigation supplies on board to the extent they're needed. There's never been any instance of any inadvertent discharge. There's never been any instance of any spills on the property during the time that Connolly has basically been operating up there. Other than routine maintenance, checks for leaks, fluid checks, wiper bulb replacements, or safety repairs to the mirrors, no vehicle maintenance will ever be done on that property. It doesn't need to be done, and it will not be done. All bus repairs and maintenance, including engine and body work, are done right now at the company's maintenance facility in Walpole. They will continue to be done there or at another off-site location. We will be installing a dumpster on Lot 2. That'll be utilized to deposit trash from daily bus sweeping and any driver personal trash. Accordingly, we suggest to you that environmentally we're being sensitive and not adding environmental stresses. Since 2010, all buses have significant emission technologies. It makes the bus more complex, but it helps the environment. All buses are 3 years old or newer. They all have the factory exhaust smoke systems incorporating this emissions technology. There's simply no longer any, quote, black smoke. This is in significant contrast to the construction vehicles of M.E. Smith that operated on the site, which belched a lot of smoke, made a lot of noise, and didn't have this type of technology. The school buses do have to have mandatory backup alarms. They are required by law for the children's protection. We can't shut them off. The alarms are activated as required by state law during mandatory pre-trip inspections and when parking the buses in a backward fashion. They are not, quote, overused. Potential fiscal impact. The proposed use will not cause adverse impacts on town services. It's not going to do the same thing that a building development would cause. There will not be the use is a benign use, and I use that word advisedly, and I'm really speaking about the fiscal impacts. It will not cause any type of additional financial stresses on the town. Will continue the ability for the town to make its excise tax payments. And certainly when they now own the two lots, real estate taxes will certainly increase because, as you know, when the town reassesses the property, they will take a look at the deed price. And although that price is confidential now, it will cease to be confidential upon passing. It will definitely require a reassessment of the property for the benefit of the town. For the foregoing reasons, I think we will be able to satisfy the criteria. With your permission, I'd like to have Bert go over the plan and take you through
Before
it.
you say, any questions for him before we hear from the engineer? No? And we should decide who's going to sit on this one. I don't need to sit on it, but...
Sure.
You want? You, okay?
That's it.
Okay. Okay. All right, great.
So, who do we have?
Brian, John, Dimitri. You're up.
For the record, Bert Corey with Stoker Brothers. I think I'm going to try a lot of what Mr. Efron has already talked about. But just to start out with, let's go over the existing conditions. Chestnut Street, 135.
Mm-hmm.
Parking lot entrance is right here, off of Brook Street. That's where it's used today, and that's the way it's proposed. Under the existing conditions, all of the parking, all of the buses are currently parking on lot 3. There are 45 buses on that lot. There's also some car parking on there too for some of the bus drivers that are driving buses. So there's, let's see, there's 48 cars that are associated with that. On lot 2, it's all car parking. There are no bus parking. And there's 117 car spaces on that one. So in total, there's 210 vehicles that could be parked on both these lots. Like I said, access is off of Chestnut Street. Yeah, that's it for the existing conditions. Really not too much to talk about there. The proposed conditions. This lot 3 will be used solely for the bus parking. And under that, there would be 59 buses.
What was the original number again?
That was 45.
Okay.
On lot 2, there's actually 9 buses.
59, you said? 59?
59.
45 to 59, yeah.
On lot 2, there's a proposal to have 9 buses on that lot. And the car spaces is only 72. So in total, there's 140 vehicles occupying those two lots. So there's actually a reduction in the vehicle spaces over there.
Yeah, I know this is in the application, but so how many additional buses in total?
We went from 40, there's 68 total buses. So
And what was the original number?
on the existing conditions, we had.
Was it just the 45?
Yeah.
Okay. So 23.
And there's certainly a reduction in the car parking too. Access would still come off of Chestnut Street, as Mr. Efron mentioned. The 2 curb cuts that are shown on this proposed plan are not to be implemented. They would only be implemented if
And where are those?
accessing each lot.
Yeah.
Both of them fall within the jurisdiction of the Conservation Commission now, so it'd have to be another condition.
Yeah.
As far as the proposed work, the access is still going to come off of Chestnut as it does today. Coming down Brook Street, there's actually 3 openings into lot 2. This 3rd opening is proposed to be closed. So the only access onto this lot for any cars or buses would be within these two openings. Buses would have to come into the 2nd opening in order to make their maneuvers into where the bus parks today. We retrieved the design information of these buses from Connolly Buses and ran turning templates to see how these buses could maneuver. And I know it's a little bit conservative, but it does in fact make the maneuverability within this lot, as well as in this lot too. The porta potty that was mentioned is in this location here, and it's 68 feet away from the abutting properties. The dumpster is placed up in the front. And then there's snow disposal areas that are distributed along Chestnut Street, along the abutters on the west side of lot 3. And there's additional snow storage area in the north corner of lot 2.
Do you lose spots for those?
No. There's a reduction in spots anyways.
Reduction in cars, right?
Spaces.
Spaces,
Yeah.
okay.
Yeah.
But the snow storage doesn't eat any of those up?
Well, if we didn't have that snow storage area there, we might be able to add some additional spaces in
But if you're 140 count, none of those would be reduced by snow.
Correct.
Okay.
The snow storage is to push the snow off to the shoulders of the road. Once it exceeds the limitation of the height of the proposed fences, then if there was any additional snow and there's no snow storage, then it has to be trucked outside. As Jerry mentioned, there would be some signage on Brook Street to inform the drivers that once they're in their vehicles, their personal vehicles, they cannot turn up Brook Street and onto Columbus Ave.
And when you say the buses always access those lots through Brook, what's preventing them from using, was it Columbus?
That would be a very difficult turn for them to make down Columbus and onto Brook Street.
Okay.
Didn't even bother running a template for that. I think as it's today and as it's always been, there's really been no buses that travel down there.
When the sewer was done, they had to go that way.
They diverted when the sewer was through a detour.
So it's not impossible. I mean, that angle's not, it's just difficult, I get it.
Must be challenging for the driver,
Yeah.
but must be fun.
Okay.
That's about it.
Oh, yeah, question.
What is precipitating the increase in the number of buses?
It's not that's where I was gonna go.
Oh, okay, go ahead.
I omitted to tell you that the company also parks 13 buses on Homer Ave and another location that's also leased. It's also been there for years. It was there with Ed Nowles as the prior owner of the property, predecessor entitled to W.D. Homer's predecessor, and then W.D. Homer. We're still parking over there. So we're getting out of that location. We're bringing all the buses here. The additional room for 10 buses is for necessary expansion. The town of Ashland just notified us we're going to need 2 more buses next year. We anticipate, just based on Ashland alone, that they will fill to that capacity sooner than later, based upon a lot of the things you've heard and a lot of other matters, that there's expected to basically be a little bit of an increase into the school system.
So of
But
the
right now, we are parking in 2 locations, a total of 58 buses. And we're now providing for 68 buses in this one location.
So it's 13 on Homer. And how many of the 45 there are Ashland buses?
I mean, where do the Hopkinen buses park?
Yeah.
How many?
Do you know the answer to that question?
About 18.
18
16 and 2 spares.
at this location?
Yes.
And then what about the 13? Any of those Ashland or those?
They're keep, all keep.
They're
all
Ashland,
Keith.
they're Keith Tech.
They keep.
All covers and all those premium.
So almost a 200% increase for Ashland to eat up those 23 new spaces.
I'll trust your math.
Yeah.
But we're seeking approval for 68 bus spaces combined with the 2 lots.
Yeah.
We will be vacating the other location on Homer.
Is out of necessity or just consolidating out of choice?
It's a number of things. When we negotiated to purchase this property, part of the reasoning was we would no longer need that property. If that wasn't available to us, we would stay over there.
Okay. No, I get it.
I have another question.
Yeah.
I guess the small one is lot 2?
Correct.
Okay, where are what's the orientation of the buses on lot 2 specifically? Do they have?
Under proposed conditions, they are.
Right in the middle?
Yes, or this is the lot.
Okay, but.
There's additional parking over here.
Right.
So they're parking up against the edge of that existing parking.
But they're not abutting the residents on.
Here's a residence right here.
Okay.
So this bus right here would touch the very tip of their property.
And what about?
This is all cars. They're all
Okay.
cars. So the 9 buses are right here, in this area.
And why did you choose to locate the porta potty 68 feet away when you could have put it right next to the dumpster out on Chestnut Street?
He didn't make that choice. It was our prior engineer, so it's a tough question for him to answer. I think, to be honest with you, they put it in a location that's deemed convenient, but as they indicated in my opening, it can be moved.
So it can be moved?
Yes.
If the residents object?
It can be moved if there's plenty of room within that lot to move that forward.
Other questions?
It's a little further away off of Chestnut Street, too. A lot more traffic coming on Chestnut Street. Putting a water tower out here is a little.
Yeah, but I'm just looking at the servicing of that, the cleaning of that, you know, if you get it away from the, well, I'll let the residents speak to themselves, for themselves, but.
It's well taken, though. Taking the same thing.
Okay.
Good evening, Mr. Jack and members of the board.
You want to ask if anybody's going to speak in support before you get there?
Is there, I always do all the, well, you're technically the public, I suppose. I will. And is anyone here in support? Speaking in support?
I didn't hear what you said.
He wants, is there anyone in the room who wants to speak in support of the project? You should probably never ask a question you don't know the answer to, right?
I don't know the answer.
I know.
Are you making a straw vote,
All right.
Mr. Chairman?
No. All right. Floor's all yours.
Thank you. Good evening, Mr. Jack and members of the board. My name is Amanda Zaretti, and I'm representing Elaine Kelly and members of the Columbus Avenue, and Brook Street neighborhood. In support or opposition, I'm not sure that that's an accurate characterization. What I'd like to do is just frame the contents of the letter that was sent to the board last week, and then pass the podium on to Mr. Trainer, Mrs. Kelly, and some other members of the neighborhood to address each of our proposed conditions. If I may, I'd also like to begin with setting out the standard for the special permit, and then addressing very briefly Mr. Efron's points. The bylaw section 9.3 actually says, quote, that the adverse effects of the proposed use will not outweigh the beneficial impacts to the neighborhood, not the town as a whole, in view of the particular characteristics of the site and of the proposal in relation to the site. And, Mr. Trainer, who will speak after me, has resided in the neighborhood since 1957, and he can certainly speak to the historical use of the premises and the increase in the parking volume and the increase of the hours of use of the parking lot. So I'll leave that to him. One of the things that the neighbors are concerned with are that these 4 points. One, they would like to see suitable fencing and buffers installed that are consistent with the requirements of zoning bylaws section 5.4.21 and 5.4.23 as set forth in my letter. They would also like to have the applicant cease the use of Brook Street and Columbus Avenue. While there is a statement by the engineer that Columbus Avenue hasn't been used for bus traffic, I'd like the neighbors to speak to that. We would also like to see that school bus parking be limited exclusively to Lot 3. We recognize that that may not be a workable special permit condition, but nevertheless, we would like this board to consider that. And the neighbors would also very much like to have conditions included in the special permit that would cease pushing snow against the lot lines of the abutters' residential properties, and also to change the location of the porta potty closer to Chestnut Street. And from the correspondence received from Ms. Page, we understand that at least moving the porta potty and some of the other conditions are agreeable to the town planner as well. With regard to Mr. Efron's discussion about other uses that may be less impactful on the premises, those uses, even though they may be approved as of right under the zoning bylaw, are really irrelevant to this permit application. So the balancing test that the board is faced with is not whether this use is less intrusive or less burdensome on the neighborhood than some other hypothetical use, but what the applicant's permit proposes. In terms of just framing whether or not the zoning bylaw allows parking, You know, one of the things to bear in mind historically, and the neighbors can speak to this better because I'm not in the position to give testimony, is that the increase of parking, from what I understand from them, on Lot 2, which currently serves the Ashland Technology Center and the Encompass Gym, is roughly about 47, maybe 50 cars. And there's a proposed increase to 72 cars and to 9 buses. And there's also an increase of the buses, as you've just heard, on Lot 3. Something to be considered is that the bus contract for Connolly is for 5 years. There will be more than likely a successor. So I think that it would be very prudent for the zoning board to include particular conditions to address all of these things, and specifically to add a condition that snow be trucked off site in addition to not be pushed against the lot lines, and further that any protocols with regard to Connolly's employees actually be included as enforceable conditions within the special permit regarding the use of Brook Street and Columbus Avenue. More importantly, though, there's been a proposal that the curb cuts be put off until a later time. You know, just looking at the location of this lot being so close to the Sudbury River, and given the jurisdiction of the Rivers Protection Act, there are 2 thoughts that I have before I turn this over to Mr. Trainer, which is that the proximity of the Sudbury River really leaps out at you if you have any familiarity with real estate and zoning law. So that's a consideration that couldn't have gone unnoticed. Secondly, you know, if you go on to Chestnut Street from Brook Street in the morning, which I have for several days just to see, 2 additional curb cuts certainly will require some engineering, but it's not impossible to present those before the Planning Board and the Conservation Commission for review, which would significantly alleviate the traffic on Brook Street and Columbus Avenue. Having said that, and given the lateness of the hour, I'd like to turn the microphone over to Mr. Ray Trainer so that he can share his observations regarding the need for the fencing and buffers.
And that's fine. Can you just sort of highlight where there's still a difference of opinions? You said the applicant has addressed some of your concerns. What's left?
Really, the plantings that would accompany the wooden fencing.
So screening.
The screening has not yet been determined. Mr. Efron had proposed to the neighbors an agreement which they can speak to, where there would be the offer of a stipend for plantings. Not sure where that stands. Not sure whether to characterize it as a quid pro quo for you know, agreeing not to oppose the permit. The neighbors are not opposing it. They recognize that this is something that the applicant has every right to approach this board for. What they're requesting is reasonable, workable conditions to protect their interests as required under the bylaw.
Oh, sure. So, yeah, and so, but just again, we get all that. What's left of those conditions that he hasn't agreed to besides the screening?
The curb cut is a condition that the board has within its purview to require.
Yeah.
We also recognize that the board may decide to waive that requirement, but what we would ask is that there be a condition saying that the special permit also requires that the planning board and the Conservation Commission approve the curb cuts.
And you said you prefer buses limited to Lot 3 if feasible?
That is the preference expressed by the neighborhood. Again, the board has the ability to determine whether that's feasible.
What's the rationale for that?
The rationale is that the 3 of the residential properties face Lot 2. Currently, if there are in fact 47 to 57 cars, increasing that to 72 cars and 9 buses is really a dramatic increase. And along with that comes exhaust, noise, possible debris, just the ebb and flow of people and vehicles, which is already burdensome on the neighborhood without screening.
The porta potty issue sounds like that's put to bed. I mean, he'll move it as needed. Okay.
The dumpster up near Chestnut Street, I'll let the neighbors speak for themselves as to whether that's acceptable to them.
Okay.
But putting just protocols that are not as regarding traffic and trash that are not part of the special permit, I think is not a wise choice. If the applicant is going to agree to those as a protocol, there should be no objection to including those as conditions to the special permit.
Okay.
Mr. Trainer.
Hi,
Hi, Ray Trainer from 8 Columbus Avenue. Our family's owned the property since 1957, long before there was any parking lots, just one. The original use of those parking lots was an ancillary parking to the permitted structure on 200 Homer Ave, which is, I don't know what they call themselves now, but all of that parking was for that building. It was never a commercial parking lot. It was always for employee parking. No trucks have ever been parked there from any of the businesses, and it's always been just car parking. The buses moved in 20-something years ago, and all that was originally parked there was the Ashland school buses. That number at the time was down around 10 or 15. Nobody cared. They were down by the river. As the years go by, these numbers of buses just keep creeping up. The fact is, to the best of my knowledge, there was never any permits ever pulled to officially park buses there. So the fact that they've been there for 20 years, in my mind, they've been there illegally, which doesn't make it right. So the history...
I think the argument is that there was no zoning requirement at that time for commercial parking lot.
History really shouldn't fall into this because it was never really allowed. And as far as no impact on the neighborhood, well, the backup beepers alone, a standard backup beeper goes from 97 to 107 decibels. Multiply that times possibly 59 or 60, 3 times a day, or at least 2, plus the overflow of buses coming in from sporting events and stuff at night. My office is on Columbus Ave. The buses were stacked up the other day trying to back in. That's just what they do. And these beepers were just going on and on and on. Unfortunately, they don't just pull in and zoom in and shut them off. They're all trying to get in at the same time. There's the visual impact.
Can you give us a sense of that? Like on a typical day, when are you hearing the beeping?
Well, they usually come back. They usually start flowing in. The Hopkinton buses start flowing in around 9 because in order to get onto 135, there's all of those buses. And it's between 9 and 10, and then between probably 2:30 and 3 o'clock and 4 in the afternoon.
So is it just parking or pulling out as well?
No, pulling out, you just hear the rev of the engine because they're automatic transmissions and they rev up and make a horrible noise there.
I thought they had to test the beepers when they started in the morning.
They do, but unfortunately not always. They don't always test them, but they do test some.
Okay.
But you hear the engine noise of the buses. Unfortunately, they're diesels, they're automatic transmissions. Yeah. Essentially what they're creating is a truck stop. You want to put 60 buses. Unfortunately, by design, buses are ugly. They're obnoxious looking, they're 40 feet long, they're 10 feet tall, a hideous yellow. And where they want to park the 9 buses in Lot 2 is Broadside. If they backed them up to Chestnut Street, at least we wouldn't see the whole exposure. The car parking, it's always been car parking since I was 4 years old. The cars aren't noisy, they have a very low profile. If you put up a 6-foot fence, the cars disappear completely, which brings us to the whole buffer issue of the town bylaws. They've asked if they could put in or give us a stipend to put in giant arborvitaes, space them 10 feet apart. That's an ugly tree. It's horrible looking. Emerald green arborvitae goes from anywhere from 12 to 15 feet. It stays at about a 3-foot ball, and you space them out 4 feet on center. I'm a general contractor. I've had to use them for this exact purpose a million times. It's a better looking tree. It clumps together. It makes a nice sturdy hedge, and they just look better.
So that's your request. And what's that called again?
It's a emerald green arborvitae. But you have to put them much closer together. 10 feet will do nothing. They'll look all lonely sitting out there by themselves.
So it's spaced, what's your recommendation?
About 4 to 5 feet.
And where would, in a perfect world, on that plan, where would they go?
Well, they would be along the property lines of the 3 abutters, the 3 immediate abutters, and the abutter on Brook Street.
On lot 2, just dealing with lot 2? The left-hand lot?
Yes, lot 2 and a small portion of lot 3 of the Brook Street abutter.
This home?
Yes, that house right there.
So here and here?
And also down on the lot.
Here?
Yes.
see.
Not all the way down, just where our property
Yeah,
is.
where the residential
Where it
is.
meets the other car parking.
Can I
is.
just throw that out, the applicant? Is that a possibility in your mind?
Oh, yeah. Yeah, you're not gonna push me aside, don't worry.
Pay to watch that.
We offered a stipend because we don't want to put the trees on our lot, because we think it's going to compromise the already somewhat restricted use of those lots, because we don't want to maintain those trees, and because we don't want to have the trees, the root systems, when they developed, interfere with the paving and require the continual maintenance. So what we offered was we priced out some trees in what we thought was a fair manner. We divided the perimeter by the amount that each property owner bore to the total ratio of the perimeter, gave a cost estimate on a spreadsheet, and then offered each of them that stipend to plant and maintain on their own property. And again, it would be proximate, or would be whatever the heck they wanted. So the other, I guess, position with respect to that is this, is that, and we could kind of get into this, I suppose. I spent a number of minutes in talking about our being existing. I think that bears on whether or not the general bylaw applies. We're not here arguing a non-conforming use permit tonight. We're not here arguing grandfathering specifically tonight. But it's our position that those general portions of the bylaw should not apply to this particular buffering situation. That's normally something that would be applied in a planning board with some degree of discretion. We suggest that the fence will accomplish the purpose, but in understanding, frankly, the content of what is said, which we get it, we thought that an equivalent measure of protection with some flexibility would be allow for the planting on their property. We wouldn't presuppose to enter on their property to plant, because that's usually not a good thing for anybody to do. And so we offered essentially monetary compensation in the form of a financial agreement to do that.
So that was a long form answer of no? Is that what I'm getting at? So you do not agree to that at this point? Okay.
As far as in their application, they said there's benefit to the neighborhood by having all these buses parked there, other than the
I'm sorry,
excise
just
tax.
one more thing on the screening. So
Yeah.
I heard a fence too. I didn't hear you.
Yeah, they show on their print a 6-foot-tall wooden basic stockade fence. But my question is, according to the bylaws, are we gonna get the buffer? I believe you call it for a 6-foot buffer in the town bylaws when you border it up against a residential property.
I'm not familiar.
Yep. Section 5.4.2, buffering between residential and non-residential uses. Such screening shall consist of landscaped area at least 6 feet wide and shall create an effective visual barrier from the ground level to a height of at least 5 feet.
Okay.
That's in the rules. So that buffer would be continuous all the way around, and the trees could be put in there. That type of arborvitae has a very tight root ball. It's not a sprawling root like an oak tree or something where it's going to lift all the parking all over the place. Rock salt, unfortunately, if you salt the lots, will kill them. But the biggest thing I have is the noise, and the original use of the parking lots for the buses was for Ashland. There's more Hopkinton buses there now than there's currently Ashland buses. Their contract is with the town of Ashland. They have to park their buses there. Okay, that's fine. But I don't see why we should bear the burden of Hopkinton, Keefe Tech, and who knows what other schools are coming in the future. It's just a lot of buses in one area, and I just don't think that we should have to bear that burden.
Okay.
Could I ask a question about the noise? So the bus noise is in game season. I know because I used to play sports in Ashland High, and we come home late. So on occasion, I'm just wondering how many times you guys hear noises like in the night or intermediate in the evening.
She can address that. But
Perfect.
let me just give her this.
All right.
There's a section there about noise, what it's comparable to. You've all heard backup beepers. You hear one or two at a time. Nobody likes them. They're a necessary evil. They got to be there. They're not debating it. It's just the number and the fact that they all filter in roughly the same time. I mean, an airplane is only at 83 decibels at 1,000 feet. So these backup beepers, you've all heard them. They're noisy. So I'll turn it over to Karen and she can go from there.
Hi, Karen Araya, 7 Columbus Ave. As to the question you had asked earlier, something about the buses running times, he was off on that. I have to say, Conley follows the rules. The buses are tested every morning. Every time they go out, there's a pre-trip. It has to be done. It's part of the whole thing. The emissions, the idling time, that is enforced as well. They do that. But saying that, you're talking about 45 buses. It's a lot, and people will misunderstand.
Can I ask you a question? How is that idle time? How do you guys enforce that? Is there someone on site that enforces that? There is somebody there, like sort of supervising the lot.
It's the law.
I know it's the law. I'm
There's
just wondering
signs
how
there. Yes, they have, and
They have somebody,
people.
okay.
You have supervisors down there. Everybody knows the rules.
Okay.
The problem is you got 45 buses leaving at different times, so they're starting at different times, so it sounds like buses are running longer than they are, but they do proceed. They do it. The sports, yes. I know in their letter they said that buses are only running this time, but as of now, we have one driver that starts at 5:30 in the morning. Most of them are from 6 to probably 10 to 7, then they're out of there. They come back, I'm going to say 8:35 to 9:15. You got kindergarten buses going out at 11:15, 11:40. They come back. You got Hoppington and Ashland, both of these times, going out in the afternoon anywhere. Some start at 12:30, but I'd say on the whole from 1:15 to probably 10 of 2. Then you have buses coming back at 3:30, 5 to 4:15, 4:20. Then you have 3 late buses that could be out anywhere between 4 and 5. You have sports trips that start at 2:30 or 3:30. They could come in anytime between 4 and 7. You have, especially football season, you have buses going out at 5, games start at 7, you're talking about buses coming in 10. Sports seasons are only certain times. But on the whole, you've got right now from 5:30 to, when we left our house today, there was still one car in that parking lot, which means this bus is still out. And that was at 7:30. So coming and going all day.
When they come in like late like that, it sounds like it's one bus, 2 buses.
Yes.
The noise level, I'm assuming, is lower at that time than when you have like the mad rush.
Yes, it is. It's just that in their letter they said it doesn't happen. It ends at a certain time. It's an all-day process.
But the intensity, where's the real intensity? during the day?
Morning and afternoon. All right, do you want to go? All right, I'm going to go on with a couple of other things, if that's okay.
You've got the floor.
I live at 7 Columbus Ave. I've lived there since 1989. And when I moved in, we had a factory behind us. We had no buses there. The parking lots were empty. The technology center wasn't even being used. The buses showed up one day. Yes, they've been there for 25 years. Conley has been there since 1998. Before that, it was McCarty, and then it was Ed and Al's. So this is the third company. They've been there since 1998, which is 18 years. We've had an ongoing problem, and something I have complained about for 20 years, about cars racing down our street to go to the bus yard, cars leaving the bus yard, racing down our street to get to Union Ave. 135. Buses do come down the street. They're told not to. The company has come forward and asked the employees not to do this. And a lot of the employees have followed suit and complied with that. And to that, we appreciate them very much for what they've done. There's been instances where people have driven on our properties. When those buses do come down and take that turn, and it's not too often, they're told not to, with the sewer project, they had to sometimes, or if something's closed, it happens, and we understand that. But it has to be reasonable. I mean, you have to slow down. I can give you instance of just recently, back in September, when they were doing the road over, it was all dirt, and we had to go down Brook Street to Columbus Ave because they were working on Chestnut. 3 buses drove by me while I was walking down the street. Dirt everywhere. No consideration, no respect. We have asked them to slow down. They choose not to. The company has tried to stop their employees. There's only a few left that do it. But I have a picture of a bus going down the street just last week, I think it was it May 2nd. So they're not always in compliance. They do, when they make that turn, they're driving on her property. It's something we've asked, we understand it's a public way and a public road, excuse me, and it's just been too much. It's not stopped. We have pictures of drivers going down there. We don't want to police it. We don't want to do this. We just are asking them to respect the neighborhood. We've been yelled at. We've been called all kinds of names. They choose not to respect their company and us. And to one of those pictures where they had a lot of cars in the parking lot, a few years back, at least in 2009, yeah, for maybe 2 or 3 years, it was Honda Bernardi leased part of Lot 2, and that's where they parked a lot of their cars. There is a sign there that says gym parking. On the whole, I'd say there's 20, 25 cars in there. So it's not being used like when Bernardi had it, they had cars parked there that stayed there. They weren't coming and going. So there is a big difference on that. We have, like I said, we have pictures of buses coming down. We have pictures of a bus in Lot 2 where they don't work, they're not supposed to be. Drivers going down our street. We just need that to stop. We understand that they're there, and they've been there. It's not always been easy, but we're asking, you know, for their employees to respect us and not to use that. The curb cuts would help immensely to keep those people off the street. I realize it costs them more money, but this is a suggestion we made to them at the meeting we had. We've made compromises. A lot of people have not used Brook Street because we know when the buses come and go. So we try not to. We've had 2 accidents between 2 buses and 2 cars, you know. Unfortunately, and this is not all of them, and it's still happening, buses pull onto Brook Street without even looking, without even stopping. For some reason, they think it's part of the parking lot. And then that's a hazard. And that's unsafe. And we're just asking for all of that to stop. Again, the curb cuts would help that. I think that's pretty much all I have to say. I don't know if you...
Questions, sir?
Yeah, we do have some, we have some pictures and some letters here from the neighbors, and we have most of the neighbors here. Because we're all concerned on this. Can I give you?
Please.
So this is a list of the neighbors here, and these are some letters and with some pictures that go along with them. And I think I have the bus pictures. You have the bus pictures? I want to talk more. He's going to go over that. We have some pictures. Thank you.
Yep, thank you.
Hi, I'm Elaine Kelly, 18 Columbus Ave. I'm the west abutter, I guess they referred to me as. To just finish up what she was saying, they did say how all their school buses have school bus license plates and registered. We have a picture of one in the lot that just says bus, which means it can be used for something other than school bus. We also have a picture of buses already parking in the lot 3. Is that what the one on this side is?
Lot 2.
Lot 2. Here's a driver coming down the street, another driver coming down the street, another driver coming down the street. a bus coming down the street, and this is the one that was just this Wednesday. And here's the Marine fueling the buses with the gas spilling underneath it. And I think that wraps up the stuff for her. I'm going to talk about the flooding and the snow. My yard does flood. He says it was the M.E. Smith company that's causing the flooding. I know pictures were submitted. This is Saturday's rain, and you can see the water flooding, already pulling up against the fence in the back. That's my backyard. And in the wintertime, when the ground is frozen, this is what my yard looks like coming off that parking lot. So as far as needing a buffer, I need one. And
Can you just point to your house on that plan, so we're all in the same?
And also, my other neighbor who lives at
okay.
14 Brook Street also has flooding issues with water when there's a good amount of snow that floods into her backyard. She doesn't have any pictures of it, but it does also flood in her yard. So as far as them with where they want to move the snow, it doesn't seem to make sense to push it up against the abutting properties because the drain for Brook Street is at the corner of Brook Street and Chestnut Street. So all the snow should be pushed forward at least, so when it drains, it goes there.
And how long has that been happening?
That's been happening forever. This was way before M.E. Smith. So, I mean, it's been an ongoing issue with that parking lot flooding our backyard. The way it's pitched.
So right now, Connolly's not doing anything to the snow in this lot, right?
As far as we know, they're not doing anything.
Okay.
A buffer and a curb would be great to stop the water from flooding into my yard, but it does, whether they want to say their elevation guy came and assured them it's not going to flood, it does, because when it was Homer Ave using it and they would push all the snow up behind 14 Columbus Ave, right in that little corner, it would all melt down and take a turn right into my yard. So it is pitched in the back, but it's pitched the wrong way. So if they're going to be paving it, great, then that means they can fix whatever the elevation issues are, but as for right now, it's
So if it's been I'm just going to address the applicant for a second. So if it's been a historic problem, do you guys mind paving it so that you fix the problem?
Maybe my engineer can speak. You answer.
Yeah. As far as the contours that are on this plan, the existing conditions and the proposed plan, actually show that the water sheds away from the edge of your property. I was
That's not my property.
You're right here?
No, over one more.
On the other side.
Right there.
Right there.
Sorry, okay.
And it all pitches right into the middle of my backyard.
Yeah, this is 179, 178, 177.
Right, that side is high, but if you see, and you can see the pictures that they have, you can see where the water pools and comes in.
Is there something trapped right here?
It comes in right to the middle and then comes all around the tree in my
Yeah,
backyard.
okay, so we could adjust that with some minor grading to have that water shift away. I thought you said you were here.
No, it does flood over there as well. I think
I can
she's
see
here.
that because-
She's over here, yeah.
There's a wetland right behind you it's pretty obvious.
And I'm not sure where, was it in the middle of your property the water comes in?
Yeah, all in the back, like the whole back corner.
The whole back corner?
Yeah, and that continues on out from your property out to the brook essentially. You can see all the skunk cabbage out there. It's a wetland. And there's standing water out there right now without any snow or anything. This corner here though, it's in minor grade.
Right, it's back in probably about 20 feet where the lowest spot is, and it all decides to.
Can we slightly raise and berm with a minor increase in material when we?
Yeah, a nice 6-foot buffer with a berm would be perfect. And that's where we're kind of missing. They did approach us yesterday, I believe it was yesterday around 3:30 with the offer of the stipend for the trees and stuff, which is something we brought up to with a meeting with them at the end of April when we spoke with them. And we did mention, because they told us they weren't in the tree business, that if they wanted to give us a stipend, and we could probably convince the neighbors to plant the trees in our own yards. But now it's come up. So, and we just didn't have enough time to get all the neighbors together and find out, and then it just didn't seem to work out.
Is that a planning board
It's very great.
I know.
jurisdiction, or is that ours?
Which
In
part?
terms of conditions for these improvements?
I'm assuming we can put reasonable conditions on this. being a special permit.
You can.
Yeah.
Mhm.
So we
can do that, yeah.
Right, and all the things that we've put in our letter and we've spoke with our attorney about, and we actually offered them, is everything that was written in the zoning laws with the 6-foot buffer, with the trees, with the fence. We're not asking them to put in some beautiful marble wall with lattice and wrought iron on it. We just want a fence. All the people that now are going to be coming in to use the bus yard are going to be parking behind my house, behind my neighbor's house, and behind Ray's house. So now that noise in the morning, and now we have a lovely new bylaw for 7 in the morning for the nuisance noises. They can't make a lot of noise, which goes on right now. They come in and we understand they're excited, they're at work, they talk. There's a lot of door slamming, there's a lot of car alarms that go off. There's a lot of yelling, there's swearing. We actually have some people peeing, I guess, but if, you know, putting up the fence and the trees will certainly protect us from the noise that is now going to be there first thing in the morning. And the porta potty, if they can just move that way up to the corner of Brook Street and Brook Street and Chestnut Street, that'd be great with me if they put it behind some kind of screening. We just had the M.E. Smith factory there, or company there, with a porta potty in my backyard. That wasn't so much fun. So the further away, the better for us.
And I think they've agreed to that.
Yeah.
Just question for the applicant then. So on this property line here, what's the objection to the 6-foot buffer?
Right now, actually, I think they're pointing to this property line right here.
Mm-hmm.
Right now, there's actually a landscape buffer that's 5 to 6 feet in width. There's actually a small cut in that, just for the parking that's in here. You always need to have that extra 5 feet just as you're backing out. You back into your car. So there's a small cut right here, here, and here, just to facilitate the moving of the vehicles. But otherwise, there is some landscaping right along this property line right here, and it's about 5 feet in width.
That's inaccurate.
There's nothing there right now, and actually my yard goes into the parking lot, and we have markers.
No, but under the proposed
Under the proposal.
Oh, okay.
Well, the picture says not to scale, so we can't tell how big it is there, but I mean, we're not asking for them to put a 6-foot ring around the whole parking lot. We just want it up against where the properties are, the residential properties.
It's 5 feet. There's a 5-foot landscaping buffer right
Okay.
here. Again, there is a cut coming back to the property line, so the pavement would extend to the property line, just to facilitate the car that's backing out of here, give them a little extra room to back out and go forward. Otherwise, it's shown on the proposed plan.
And I don't want any buses in that lot either. We have pictures, actually, I can probably give you the pictures. Every single house in our neighborhood, with the exception of one, can see what's in that parking lot. And looking at big buses sideways isn't our idea, and where they don't need the buses now, maybe in the future they will, maybe they need them in 6 years, but in 5 years they might not have the Ashland contract. So to permit them to have the 69 buses right now when they aren't needed, I don't think any of the neighbors would be upset if you told them that they all had to stay in the original lot.
Thank you. And just a question for the applicant. So right now you said the plan is to put 9 buses in lot 2, but are you asking permission to put as many buses as can fit in there, or are you limiting yourself to 9 in the future?
Look, going back to your question about 40 minutes ago, I'm sorry, I'm not trying to. I'm more comfortable that way, frankly. We have proposed conditions. There's no conditions on our use now. If there's no permit granted, there'll be no conditions on our use, and we'll resort to other manners to establish our zoning rights. We put in the proposed conditions that I filed with you limitations. We want those in there. We can't put in 11. We have to say 9. We can't put in 63. We are willing to have the limitations as restrictions. We are willing to have the protocols as restrictions. We are willing to be significantly restricted and regulated, and we'll worry about the manner of extending our agreements with the town of Ashland. So, frankly, one of the issues here, and I very much appreciated how gracious Elaine was in her comments tonight, especially in terms of talking about the stipend and that they didn't fully evaluate that. Just so you're clear, it really goes to the issue of we would prefer to have the trees on their property, and we'll pay for them, than on ours for a number of reasons, including maintenance responsibilities. We don't disagree that it would be a good thing to have that for the benefit of the neighbors. All we said was, look, if for whatever reason we don't get the special permit, we're certainly not going to put those in. We're going to put those in, if so, and then we would make a binding enforceable agreement to be reviewed by their council.
And so the plan for the current 5 to 6 feet of buffer, just grass? I mean, what's the plan right now for that?
I believe it would just be a grass area.
But you don't want to put trees in there for some reason?
There's no water on the site, so there's no way to maintain trees or grass. So a buffer with something that is inorganic would be perfect.
And where's the fence? The outside of that, like right on the property line, the fence?
Right. Something you don't have to maintain, you have to water, not maintain, but water.
Okay.
So we have no utilities on our property.
What's that?
Not grass, park mulch. I mean, it doesn't-
Oh, mulch, you're gonna mulch it,
Stone
okay.
or whatever.
All questions?
And then I have these that I can, one letter is from, oops, you don't want to.
I have a question for both the residents and the bus company. Can you tell me about the traffic flow? I mean, is there any suggestions, or is there a problem? And if there is a problem, is there any solutions for the problem? In other words, i.e., is there a need for like supervision for the exiting or entrance of the buses by, let's say, a
The
police
residents
officer?
are going to say yes.
Pardon me?
The residents will say yes.
So
There is some need.
tell us about that.
Well,
that problem.
they are, I have to say, they are trying to, with the employees to try and maintain what's going on. But as you can see from the pictures, it's not 100%. It's not great. I mean, as of May 2nd, we had a school bus, and an old school bus at that. It's not one of the
I'm not talking
special ones.
about, I wasn't specifically talking about, let's say, a rogue bus driver, doing something that he was told not to do. But I'm just talking about the normal flow out of the parking lot and the flow into the parking lot at certain hours. Would it be facilitated by, let's say, an auxiliary police officer or something like that to help the
Well, let me first. Well, let me explain something. I actually work for Michael J. Conley. I'm a bus driver here in Ashland. They can do for yes, for now. I hope to be. I'm not going to go there, but anyways, they can do it on their own. They just there are 2 supervisors there. They're there most of the time. They're not there all the time. But the employees can do it on their own. You're coming from a parking lot onto a street. What would you do? All you have to do is stop, take your bus, stop, look this way, look that way, look this way, and say, okay, one more look and go. Any normal person would do that. Same with their cars. A lot of them make a choice not to do that. They seem to think that Brook Street is part of the parking lot, and it's not. I think it's a waste of their money to have auxiliary police there. It's just something that they say they're going to work on training with their drivers, which they're going to have to, unfortunately. It shouldn't be happening, it is. If the drivers would just do what they're supposed to do, and safety first should be in everybody's mind that's on those buses. Even when they're leaving in their cars, when they come on to Brook Street, see, I've had this problem on Columbus Ave, they come flying on without even stopping or slowing down. They tend to forget that this, and like I said, they have helped with that, but it needs to get better. But the drivers leaving the parking lot, common sense, stop, look, then go. Make sure it's safe. Same with the buses. Again, I would say it wouldn't hurt to have that, but I don't see why they would have to if the bus drivers would just do what they're supposed to. Or, yeah, even going out of Brook Street, there's a stop sign there. And people tend, it's like anybody. Some people just want to go, they don't want to wait. But the drivers pulling out of the parking lot in their cars don't stop either. They just come flying out like it's part of the parking lot. We live there. We raise our families there. This is where our homes are. We just want to be safe. This is common sense stuff as far as I'm concerned. They have tried. They have spoken to them. And this is something they have said to them for years. You know, slow down, be nice, you know, but they choose not to. The employees, some of the employees, you know, I feel bad when I say it. But unfortunately, it's those few or more that make us all look bad. But just take a second and look. If they do that, it would solve a lot of it. But the curb cuts onto Chestnut Street would help us immensely with that. Can't stress that enough. I understand it's more money for them, but it would help us. We just want to be safe. You know, we raise our children there. Brook Street has no sidewalk. Columbus does. But I walk to work in the afternoon, and I got to walk by these, and some people aren't very nice. So I don't know if I answered your question or.
Can I just give an answer just to your question, nothing else? We don't use Lot 2 right now. We have all our cars and all our buses in Lot 3. It's crowded. We believe by having Lot 2 available for us and having all the cars over there and only a few buses, it will allow for safer access and egress onto Brook. In addition, putting aside the fact that there's public ways, there's simply nothing whatsoever prohibiting either cars or buses from going up Brook Street and onto Columbus. There's nothing legally preventing it. There's nothing at all. Now there will be if these conditions are imposed on the permit. So we believe that that will alleviate the neighbors' concerns in that area. With respect to rogue drivers, it's very difficult for me to comment on how any board addresses illegal or improper conduct.
Right.
So all I'm saying is
That's why I
that,
use the word rogue, because.
and I appreciate it. We are addressing it because we're suggesting that our protocols, which would normally be something between us and our employees, be attached and incorporated into the conditions. We believe it gives it significantly more teeth.
I'm Pankaj Rangan. I live at 14 Columbus Avenue. I'm right behind the Lot 2 parking lot, and I am left to the Elaine's house. So we have seen a really serious issue on the Columbus Avenue traffic. I start my day very early. I start to the work around 6:15, and I almost got hit 2 times by the bus drivers. They come down flying from 135 to the Columbus. They go all the way onto the other side of the road to take their turn because they are so fast they cannot turn on the same lane. And I'm just coming out of the Columbus Avenue, getting onto the 135, and I almost got hit 2 times there. But probably it's the same driver. I don't know who. I don't drive with the speed gun with me. I don't know what is the speed, or I don't go with the cameras capturing the number plate. But this is what happened 2 times to myself. And this has been the issue ongoing, and starting from the initial meeting with the bus company, we have been iterating the same thing. And I got 2 very young kids, and the buses starts very early. Somebody starts around like 5:30, 5:40, and one by one the bus keeps going almost till 7 o'clock. So the bus engine revving up, they're testing. So almost every day they wake up both of my kids every day early morning, and it's a hard time for our family to make them go to bed in that early hours because the noise is constantly. And now we are asking to have more buses on our backyard and more cars on our backyard. Cars still might be better than buses, but it's not going to ease any of the problem that we are already having. Now, the another point I would like to mention is as this parking lot being utilized for Hopkinton, Cafe Tag, and Ashland, and the bus company is saying that they're already getting requests from Ashland that they want to increase buses. I'm pretty sure they are getting requests from Hopkinton and other area that they are serving. So this lot is not being acquired just for serving Ashland. And whatever bus is required for Ashland, they can, on the current lot 2, there is more than enough space to accommodate all the buses required for Ashland. So why the Ashland residents needs to take the burn from other towns' growth? That I clearly don't understand. And the lawyer from the bus company kept saying that The construction company, I'm not sure why we are bringing that point over and over again, because this case has nothing to do with the construction company. Probably they're just trying to divert the attention from what is the problem with the current case to the what was the worst earlier, and I don't know what they're trying to do. Maybe it's a lawyer's game, but. And the last point I would like to mention is, as the lawyer already mentioned, that as it is serving school, they don't have to follow the bylaws. I don't agree with that, because the buses are not owned by the Ashland town or Ashland school. The buses are owned by a private company which is for profit and which is contracted by a school. So the company is making profit out of it, and it's a commercial. It's not a non-profit, or it's not a trust. So they have to follow the law. The only thing as all the residents we are asking is follow the law. We are not asking for anything extra, no any cashback, no kickbacks, nothing. We just want company to follow the law. Put the buffer, put the fence, whatever required by the bylaws, just do that. We are not asking for anything extra. And even if you put the more buses there, it's definitely going to affect our views from our houses. And if the 6-foot buffer and the trees buffer is definitely going to help us. I have a letter that we have already submitted to the planning board somewhere around in January. I would like to submit as a record, and I have a picture of the view from my backyard.
Great. Thank you.
Sorry again.
You know what? Can we just somebody new first, and then?
My name is Linda Mercer from 14 Brook Street. I am abutting Lot 3, so I'm the house that's the closest to the buses. So when I look out all of my east windows, we see buses, and I have submitted some pictures of that to the board. And I'd also like to request permission to submit some more pictures for a close-up. Thank you. We've been there now at that home for 35 years, so we've been with the buses all that time. And I really don't have a problem with the buses being there, and I think we've been very patient with the buses. And over the years, we've had a good relationship with the company. However, it's time. We look out the windows, we see the buses. I can't go outside at 2:30 because the noise is so loud that I really can't even be out there. So there's a certain amount of time during the day that I don't go outside. If we were going to have an outside activity or something, I'd have to plan it around that time. So from 2:30 to 4 o'clock, I believe it's 4 o'clock, could be 3:45. There's a lot of noise out there because, don't forget, I'm right there at the line where the buses are, right there abutting us. And it's much better now because of the gas is different, and so the fumes aren't as bad. So over the years, we've had that issue.
And do you agree that during the summer it pretty much stops?
Well, there's no buses during the summer,
Right, okay.
but I have to say it's a short summer. You know, it's July and August, but we're thankful for that.
Okay.
But so those are my concerns with if the buffer were there and the trees were there, at least it wouldn't be so loud, it wouldn't be so ugly. You know, I mean, you look out the window and you do see these big yellow buses all the time.
And you don't have a fence now?
There is a chain link fence,
Right.
which brings me to the leaves that are there. These are leaves and dead trees that are on that fence, on that chain link fence, and up Brook Street where the buses park, between the two lots. And there are dead trees and leaves there that are at least 5 years old, maybe 10. I mean, I really believe that there should be some general maintenance there. You know, over the course of time, there should be some kind of plan to keep that area clean. I mean, even though there are buses there, it can still look like a nice neighborhood. You know, we may be having the buses for a long time, so I mean, why not make it look nice? I mean, it really wouldn't take much. There's this chain link fence that's all dilapidated.
But my understanding is that you're taking that down and putting up a wooden fence, right?
Is that on the two sides there of Brook Street?
I believe the plan is showing a proposed wooden fence coming across through here, so on your property right here. It says proposed wood fence.
That's the proposed wood fence?
Yes.
Would that help?
There's also a proposed wood fence over here, and at the edge of the parking to the property line, it's an 8-foot buffer right now from the edge of the bus parking to the property line.
Does that go all the way down?
That actually starts right here at Brook Street, and it continues on down to beyond your property and to the south towards the brook.
Toward the end of where the buses park, the end of the lot?
Yes, yeah. So all the buses are parking right here. They're coming up against your property line. Before they get to your property line, there's a buffer zone of 8 feet with a wooden fence along, starting at here. The wood fence, I think, would end at your property line, right at your property corner. But that 8-foot buffer does continue past that, towards the end of that bus parking.
Okay. I'm also speaking about the sides of the street on Brook Street. That's where there's some chain link fence that's dilapidated and some dead trees, lots of them, on both sides of the fence.
Could you just point that out where?
If I can. Excuse me. Okay, here's Brook Street. Okay, yes.
4-foot high chain link fence right here.
Yeah, on each side, there's like sections of fences, because earlier someone mentioned that there's openings for the buses to come in and out. So there's sections of fences, but they've been there for a very long time, and they're all dilapidated and tangled up. And then there's dead trees that intertwine with them, and all up and down, and it's really ugly.
Okay. I know that this portion here, there's an opening between here and here. That is to be closed. And return back to something that's not going to be a grass area, but be a park mulch or stone. There isn't anything on this plan that I've seen anyways that says that these fences are supposed to be replaced or removed. The fact that they are there at least does give some kind of an indication as to when people are coming across these two lots, at least there is some type of a barrier that will say, oh, you're going to slow down.
But they're a mess.
Are you guys planning on replacing those? Or?
2 points. Trees are on town property. Those trees, they're in the way. They're in the public way. They're not our trees.
Okay.
All right. We will repair and replace, and you can include in condition any portion of the fence that's dilapidated or in disrepair. Meaning the fence that's going down, the chain link, not the one in the back that's going to be replaced, but to the portion of the fence that's going down Brook Street, to the extent any of it is in disrepair, it'll be repaired and replaced. You can put it in as a mandatory condition.
Replaced with like kind, though.
I'm sorry. I don't disagree that portion of that fence is in the condition that she's.
Okay.
That's all I had to say. I just wanted to thank you.
Thank you. Thank you. This kid's falling asleep in the back here, so we got.
One thing that has to do with Columbus and Brook Street. We had meetings with the traffic committee, with one of the sergeants at Ashland. We did request residents-only signs. The speed limit is 30 with a 70-degree angle to go onto Brook Street from Columbus. Speed limit is 30 because there's nothing posted. We've asked for a lower speed limit. We've asked for no entrance during these times. We've asked for residents only, and we were told they're all illegal. We can't get them. So we have tried other things we just want you to know that we have tried our best to work with them, and we tried to ask for all that, and we were told they were illegal, so we couldn't get any of that. Thank you.
Yeah.
1 second, Mark. Solely on the issue of parking Hopkinen buses, I would remind the board that the bylaw for the commercial parking facility does not say anything about where the buses have to come from. I'm also unaware of any portion of any other parking bylaw in your zoning bylaw that in any way, shape, or form talks about where the vehicle comes from. And I don't think that that would be an appropriate condition. I think the issue, if they're raising it with respect to the overall impact, that's a legitimate position. But if there were X amount of buses from Ashland or X amount of buses from Hopkinton, it's the total amount of buses which we want to limit, and the total impact, not the origin of the buses, that I think is material.
While Attorney Efron is at the microphone, may I just ask him a question?
Please.
Well,
This is for
or
you,
we can
Jerry.
let, well, we can let.
Yeah,
we can
no, go ahead.
No,
Ask
we
you.
can let Mark, the public comment finish, and then I'll ask Attorney
Well,
Efron
you know,
to
before
return to the
Mark,
stand.
let's stay there. Show of hands, who else is planning on speaking tonight? I realize you're in line. But who isn't in line right now? All right. Well,
I would just like to make one comment to you, just real quick.
we're at the mic though, so you're gonna have to get in line. Yeah, okay.
He's the about us.
Okay.
One of the things that I don't think has been brought up is that the existing parking lot that borders the river, that 3?
The one we're calling 3, yeah?
Yeah.
Yeah.
That drains into the river. I know it's an existing condition, it's nothing they created, it's not, has nothing to do with them, except for the fact you put 60 diesel-powered dripping buses in there, and it all drains into the river. And I know they try and do their best, but the reality of it is, if there's a spill, or when there's a spill, it's all going into the river. So, just so you know that, no one's brought that up to you, and I know you probably haven't looked at the contour lines that much.
I was wondering about it, so you guys don't dispute, I mean, everything seems eventually drains in that direction?
Absolutely does. Yeah,
Yeah.
it does, yeah.
Yeah.
We dispute the word leaking.
As of now.
That's why I didn't use it. Mr. DeSoni.
Okay, Attorney Berger's up here. Okay, Mark Sony, good evening. And I've been around in the area itself and as the town watchdog, watching it and doing the traffic, but I was told one time by Officer Berman on the traffic study that they were doing something about it, so I left it. I went to a couple of their meetings, and they have spoken about it. Buses, always big, always cumbersome, always take up the room. It's just like going to Mass Pike on a very snowy blizzard day. They just don't move. But this, for that neighborhood, and the agenda before, the 133 agenda before, this is what this town does when they communicates, try to compromise, and try to hear each other, is by doing this, both sides, and having the board, taking the patience to do this. To Attorney Costa, you definitely got a lot of notes there, I would guess, from both for the last two agendas, but Ashland is now being heard. I've been going around to other different towns, and it's not even close. It's just like one says no, one says yes, and one says moon's on, one says sun and all that. But it's always a good thing to have both sides here know that trying to listen, try to compromise, and try to be a good community. And with all sides being told, all the boards being listened, this is what it is. And to the Columbus Brooks neighborhood, one day it will come to fruition. But that one day you got to be patient for. Thank you.
I think you're last.
Hi, Judy Margulies. I live on America Boulevard, which is actually not that far away from here. I drive past with all the traffic every day. I am a member of the Board of Health. I'm here not to speak on behalf of the board. I was wondering if you could clarify process. Obviously, the hour is late. We have, unfortunately, a child here trying to go to sleep. And I hear a lot of discussions, whether it's drainage, Concom or whatever board may have purview over many of the topics that have been brought up. I was wondering if you could clarify what you believe is the process here tonight. Will you be considering input from other boards or other, prior to making
I mean,
decisions?
I don't see us voting on this tonight.
Okay, thank you.
It is getting late. I was hoping to stop at 11.
Okay,
Unless you
that's
guys
all
wanna
really I
soldier
was.
on.
I've been up since 5:30. I think the matter deserves a,
Clear head to.
yes,
Yeah.
thank you
Okay,
for
that's all I was
clarifying that.
interested in, thank you.
Yeah. Okay. Before we do adjourn for the evening.
I do have
Yeah,
a question
yeah,
for
that's-
Attorney
I was gonna
Efron
say,
that might help.
questions from us.
I don't have a clear head either, but I'll do my best.
Well, then you and I will have a good conversation.
Probably.
There's been reference by several of the speakers tonight, and in the documents, the correspondence that was provided to us by the residents, to a January 2017 meeting with the planning board. What was that all about?
I don't know, because we never heard from the town of Ashland until we received a letter from the town planner, Sheila Page, on February 7th, suggesting that perhaps we need a permit. We were not part of those proceedings, we're not aware of those proceedings, we're not at that meeting. So I don't know what happened at that meeting, and neither does the company.
Okay. One other question, if I may. And for purposes of this question, let's assume that a permit was granted to your client. What specific plans would you then have to go forward before the planning board and the Concom to obtain permission to do the curb cuts on Chestnut Street?
We don't have any specific plans because frankly, as I think I told you at the beginning, our engineer who was working for us ceased to be involved. Our new engineer has been on the case for 48 hours. I'm aware of the filings that now may have to be required for the Rivers Act. Before that even takes place, engineering is going to have to be done to determine the feasibility of the proposed alteration to make a determination as to whether or not it's something that would meet the standards that apply. So if in fact it is determined that we cannot meet those standards without extraordinary efforts, we would not do that. In the condition that I sent to the board, I made it very clear, and I think it parrots almost what was said, at least by the attorney, that we cannot and will not utilize those accesses at all until and unless we obtain all permits. So I would be misstating it if I told you we have definite plans to go forward. I will tell you that it's something that we're going to have to consider because the company wants to go forward. And the company definitely wants that access on the lot closest to the brook for a number of reasons. And when it was suggested, it was something that was wholeheartedly adopted by the company. And it was unfortunate that in doing so and in proceeding in that direction, it was not discovered until much later in the game that that could not be done without the appropriate permitting. So yes, it is desired to do that so long as it's feasible. It would be difficult in advance to predict what that review would entail or what engineering would have to be done. But study and research has to be done before we can make that filing.
And what's your general timeline on that?
I don't know. It would not come, we propose to continue the use of the property before that occurs, and we propose and hope that the permit allows us to use the existing access of the lots onto Brook with the provisos that we can't go up Brook, only go down towards Chestnut Street. And then we will have to determine by re-engaging the engineer post-acquisition, we can't do anything until we acquire the property, and unless and until we get the permit, that closing's not going to occur. We've extended the P&S to allow this process to conclude. So some of the things you're asking me, unfortunately, are speculative. We do not own the property at this time. We don't own both lots at this time. We're still under our lease, and we're under our P&S. Until this process concludes, I can't sit here and tell you that we're actually buying the properties. So until and unless the permit process concludes, and we're in a position then to acquire and close, then at that point it'll be appropriate for us to go out and do the research. But we would like that access, at least one of the two.
I have the answer to that question right here, if you want this paper. It's the agenda from the meeting of the planning board. Would you like that?
Yes.
Sure.
Why, it says we're on here and why we're here, why we're there.
So Jerry, are you saying that this approval is a condition on the P&S?
I'm not going to tell you that. I'm going to tell you that we had an extension agreement to allow us to seek this permitting approval. And it's allowed, we're under a rather tight timeline, but we're being given the time needed to acquire this permit.
I hate to raise a sticky question, but, or a sticky issue, but what if you go ahead with your proposed modifications in terms of the initial, you mentioned something about grading to relieve the flooding by certain properties?
Not necessarily the flooding, all it was to just, in response to the woman that brought that up with the hat, just to raise the grading slightly here, so that when it does rain, it's not going to collect in this one, it's actually going to flow in that direction.
Okay, I'm talking about the flow because water has a funny way of finding the wrong places. So let's say you flow it one way and now
Just saying minor adjustments. I'm not proposing to change all of the grading that's in here. This corner, you just want to tip up to allow that water, all of this water right now, if you look at these contours.
Right, I understand.
Brings everything to that catch
I
basin.
understand that, but that water is gonna go someplace, and it's gonna potentially pool someplace. Now, what about the parking lot on parking lot 3? Is there gonna be any grading there?
No, the grades are gonna stay the same.
So there's no one complaining about water there?
We've not heard it.
There is there is a resident.
You certainly do have water, because there's a wetland right behind you, that it's wet right now.
So
but
what-
not necessarily from the parking lot, it's from behind you, from the south. As far as these grades go, that is showing everything that is pitching away.
Right,
It's kind of
so when you say away, is that
Away
water
from-
potentially gonna go to the river?
It does.
And then we're gonna have some other people come and say, hey, wait a minute, something has to be done about this because now we're polluting the river? Or how are you gonna deal with that?
Right now, it's an existing condition. Right now, it's an existing condition. There's nothing being proposed to deal with any of the runoff here, just to let it continue the way it goes today.
But someone from the town, one of our committees, gonna say, we have to address this issue. So if we're initiating an action to relieve a condition now, it might have some sort of effect down the road or down the parking lot that's gonna affect your project. How do we deal with something like that?
We don't think the adjustment's going to be sufficient to do what you're saying it's gonna do.
Okay? Answer
And-
the
and-
question?
and that's the best answer I can give you.
Okay. Let the minutes show.
Yeah. All right, it's late, so I think you had a request, if we didn't wrap up today, which we're not going to, that we put it on, continue to the next scheduled hearing
The 23rd?
on the 23rd. Do we have anything else that
I
day?
don't believe so.
That'd be 2 weeks from tonight.
Correct.
That would be appreciated.
I think that is fine, but let's see. Yeah, and who's sitting on this again? The three of you? No, I think,
How about?
the three of you, so the three.
Wait, we need to.
No, yeah, can you guys all make it on the 23rd? I mean, I think I can anyway, but.
Who is?
Stu, I don't think you're on this.
Yeah.
I don't think I'm on
No,
this
you're
one,
not.
but
I will
Sorry to
be.
have included
We were dragging you in.
All right, so I believe that's our only, Josh, that, the only agenda item?
That would be yes.
Okay.
I mean, yeah.
7:05?
Thank you.
All right, so motion to continue this hearing to the 23rd of May, 7:05 PM.
Move that we continue this hearing to May 23rd, 7:05 PM.
Second.
All in favor?
Aye.
Opposed? All right. All right.
Thank you, Mr. Chairman.
We'll see you then.
Good evening.
Didn't ask Adam if he was available.
Adam's saying he's supposed to be here right now.
Oh,
Yeah.
I'm sorry.
He fell asleep twice, too. It was him and the kid in the back. All right. I think we're done. Motion to adjourn?
Motion to adjourn.
no, why?
But Wait, did you have something else?
Second.
Oh, second, yeah, it's like, don't do it.
Stu was asking.
All in favor?
Aye.
Opposed? All right. Thank you, everyone.